Senate Judiciary and Public Safety Committee to order. We do have a quorum present. By attending this hearing, you agree to adhere to the standard expectations and decorum of this committee as explained in the written document available with the committee handouts and any additional verbal instructions that I may add as chair. And with that, we'll start with our first bill, Senate File 4747, Senator Kreun.
Thank you, Madam Chair, members of the committee. I'm here to present Senate File 4747 today. I do have three amendments. If you want to deal with those now, or do you want me to describe the bill first?
Senator Kreun, it sounds like these are a series of sort of author's amendments, but if you can go through explaining them, that would be helpful. We'll adopt them and get the bill into the shape you'd like it to be in.
Very good, Madam Chair. I will briefly describe the bill and then I'll describe the amendments. For context, Senate File 4747 basically does two things. It allows the use of a qualified private selling officer to conduct mortgage foreclosure sales. And then the second thing it does is it permits foreclosure sales to be conducted online by these newly developed PSOs or by the sheriffs. Those are the two things that the bill does. The A1 amendment is some language that we drafted to clarify and make it clear that none of the fees associated this could be charged directly or indirectly to the homeowner at the behest of legal aid. That's what the A1 does. The A2 is just some conforming changes, deleting the word mortgage before foreclosure sales so that it's clear it applies to other types of foreclosure sales like homeowners association, assessment liens, et cetera, that do also mirror the mortgage foreclosure statutes. And the A3 is clarification to make it clear under Chapter 581 that this process would apply to foreclosures by action as well as foreclosures by advertisement. So sometimes they're called judicial foreclosures in 581, and the intent would be for this to be applicable to both types of mortgage foreclosures. So that's the series of the amendments, the A1, the A2, and the A3.
Thank you. Let's just begin with the A1. Are there any questions, members, on the A1 amendment? Seeing none, Senator Kreun moves adoption of the A1 amendment. All those in favor say aye. Aye. Any opposed? Motion prevails. The A1 amendment is adopted. And we'll move to the A2 amendment. Any questions? Okay, Senator Kreun moves adoption of the A2 amendment. All those in favor say aye. Aye.
Aye.
Any opposed? Motion prevails and the amendment is adopted. And we'll move to the A3 amendment. Again, if there's any questions, I'm not seeing any. Senator Kreun moves the A3 amendment. All those in favor say aye.
Aye.
Any opposed? Motion prevails and the A3 amendment is adopted. So we've got the bill, Senate File 4747 as amended. Senator Kreun.
Thank you, Madam Chair. The private selling officers, or sometimes I'll refer to as PSOs, under this bill, they would have to be licensed. They could either be licensed as a real estate agent or as an auctioneer through the auction license. They would be selected by the foreclosing lender. All fees associated, like I said, whether the sale is conducted in person by the PSO or online, would not be assessed to the homeowner directly or indirectly. They would be paid for by the foreclosing lender. The property owner being foreclosed upon would not result in any additional fees to them directly or indirectly. If the sheriff conducts the sale online without a PSO, that would be optional at the sheriff. This would not be required. The platform fee also could not be charged to the homeowner directly or indirectly and would go to the foreclosing lender. While the PSO would be conducting the actual auction, all tasks necessary to effectuate the foreclosure sale remain with the sheriff. everything aside from conducting the actual sale in those instances. The PSO then would be statutorily required to give the details of the sale to the sheriff, and the sheriff handles all the other administrative duties they currently have in the foreclosure process, which would include, for example, handing the funds from the proceeds of the sale and making sure they go where they're supposed to go after the sale. The benefits of this bill, Madam Chair and members, it would create a broader pool of buyers in the foreclosure process, and that would equal better sale results. It would have a broader outreach and marketing. That would equal better sale results. And property sold at the highest price possible is good public policy for literally everyone involved in the process. It's good for the foreclosing lender because they won't hold as much foreclosed property on their books. It's good for the junior lien holders who can be paid, if the property brings in more money, can be paid out of the sale proceeds rather than have to go through the junior lien redemption process. And it's also good for the homeowner. The more money that the sale can bring in, the more chance there is for a surplus, which after the payment to junior liens would go to the homeowner under our current statutes. This bill, we've consulted with a number of stakeholders who do not oppose the bill. That would include legal aid, the Bankers Association, the credit unions, the Sheriff's Association, Minnesota Land Title Association, and the Bar Association. So that's the bill, Madam Chair. With me to testify is Greg DeCastro, who's the Senior Director of Attorney Firm Relations at auction.com.
Thank you. Move to you, Greg DeCastro.
Thank you, Madam Chair and members, and thank you for the opportunity to testify. My name is Greg DeCastro. I am with auction.com, and I'm here in support of Senate File 4747, modernizing Minnesota's foreclosure sale process by authorizing online sales and the use of private selling officers. At its heart, this bill is about improving outcomes without changing rights. This bill increases participation and competition at foreclosure sales by both permitting online foreclosure sales and adding the option to utilize a private selling officer to conduct the sale of the property. Online access to foreclosure auctions removes geographic and logistical barriers. More bidders mean more competitive bidding. That matters because competitive bidding leads to higher sale prices, which in turn increases surplus funds that go back to homeowners. Online bidding opens access to these sales to more local community developer purchasers to bid, giving them the ability to participate on equal footing with larger bidders without sacrificing transparency, local knowledge, or community involvement. Increasing the bidder reach also helps reduce neighborhood blight. When properties sell more efficiently and closer to market value, we reduce the number of properties that stagnate, sit vacant, or revert back to the lender by default. Faster, more competitive sales mean properties return to productive use sooner, benefiting communities, local tax bases, and public safety. The bill also allows a mortgagee at its discretion to appoint a licensed real estate professional or auctioneer to conduct the foreclosure sale while keeping the rest of the foreclosure process firmly under sheriff control. The private selling officer's role is narrow, conducting the auction itself. All other statutory duties, including record keeping, handling sale proceeds, issuing certificates, and administering redemption, remain with the sheriff. Private selling officers add flexibility and expertise to the auction process, thereby increasing participation and competition in foreclosure sales, which helps return properties to productive use and produces higher sale prices that benefit debtors through increased surplus funds. This bill is intended to build on that existing framework by equipping sheriffs with additional tools, reducing administrative burden, and allowing for flexibility where beneficial, without requiring any change to current pre- or post-sale practices or removing authority from the sheriff's office. Senate Bill 4747 is balanced and carefully drafted with the support of industry participants. At the same time, debtor protections and notice requirements remain unchanged, and the sheriff's central role and oversight are fully preserved through an optional, limited modernization of the sale process. For these reasons, I respectfully ask for your support and thank you for your time and consideration.
Thank you for your testimony. Are there any questions for a testifier? Any questions on the bill as amended?
Chair.
Senator Westrom.
Madam Chair, Senator Kreun, I think the answer is yes, but one of the real estate, trained real estate professionals could also be an attorney, or is it just limited to realtors?
Senator Kreun.
Thank you, Madam Chair. Thank you, Senator Westrom. I think the bill as drafted is limited to real estate agents and auctioneers, although I certainly would be open to an amendment to include licensed attorneys. Certainly would not oppose that, but I do not believe the bill as drafted would include licensed attorneys.
Senator Westrom.
That was kind of why I was wondering, but if you're open to it, I think, because attorneys right now can transact the real estate also, just like an auctioneer or a realtor. So if staff could maybe help me prepare an oral amendment, I would offer that when it's appropriate. But Madam Chair, if others have questions, we can go to them first.
All right, Senator Westrom, I'll give council some time to work on a potential oral amendment here, and then we're going to go to other members to see if there's questions in the meantime. Senator Limmer.
Thank you, Madam Chair. Senator Westrom, or perhaps Senator Kreun, I've worked in the real estate business for 47 years as a realtor. There's times when I've had to interact with some attorneys, and not all attorneys specialize in real estate. And so I would think that we could perhaps narrow the field a little bit when it comes to attorneys and those that specialize in real estate or financial transactions. I have been in real estate closings when a friend who happens to be an attorney is helping a party in the sale, and they absolutely know nothing about real estate or real estate contracts. So I would caution the committee not to make it too broad.
Senator Kreun.
Thank you, Madam Chair, and thank you, Senator Limmer. I'll let you and Senator Westrom duke this one out. I think the problem with trying to narrow it down to licensed attorneys that have experience with real estate is there isn't a special license for that, although there probably should be, but there isn't one right now. And that's the magical thing about a law license. You can do pretty much anything, practice any type of law you want with a basic law license, with a couple of exceptions. So it would be difficult to draft that. But I hear what you're saying. I think the idea is that licensed attorneys have the wisdom to know what things they should go into and what things they shouldn't go into, although you might have a different take on that based on your experience.
Senator Westland.
Thank you. And just to add to that, attorneys are bound by rules of ethics which require competency and so on. And so attorneys typically are going to be somewhat risk averse. And so I think they are bound by ethical rules that would prevent them from doing something they aren't actually competent to do.
Senator Limmer.
Madam Chair, let me give you at least one example. I was at a real estate closing where the buyer had their attorney present at the closing, and the attorney looked at the sale price and said, "This property isn't worth that." And I asked the attorney, "What experience do you have in appraising value of the property seated in a commercial office, a title office? You haven't even looked at the property." And he had to pause a little bit. And by all respects, it had been appraised even by a licensed appraisal. And nevertheless, he was in disagreement with the value. And after I became a little more familiar with his practice, he had no experience in real estate. So there are times he may be honestly, in his own mind, assessing the circumstances of the sale, but had no professional experience to dictate an opinion that was contrary to a licensed appraiser. So it does happen. And again, I just caution the committee on going too far forward or too broad. I agree, Senator Kreun, that perhaps there is no way to narrow the field of attorneys in this regard, and I guess those who hire such an attorney is the one that's going to be at risk. And the client could lose a lot of money in that regard.
Madam Chair,
Senator Kreun.
there is such a thing as a certified real property specialist by the Minnesota State Bar Association. I suppose you could throw that caveat in there. Again, I'm happy to throw myself at the mercy of the committee. I don't have a strong opinion one way or another whether licensed attorneys should be able to conduct this sale. As a licensed attorney myself with significant real estate experience, I would have no interest in being one of these PSOs. So this is, and I can't imagine the Bar Association or any lawyers would push for this. So I certainly am fine with the way the bill is drafted. If Senator Westrom feels strongly about it and wants to offer an amendment, that would be up for the committee to decide. But a certified real property specialist by the State Bar Association could be a happy middle ground.
Go to you, Senator Westrom.
Madam Chair,
Go ahead, Senator Westrom.
so Madam Chair, I guess a couple of responses. You know, that same statement, Senator Limerick, could be true for realtors, and I've worked with several in my years, and some don't meet a very high standard either. And then typically my client or myself, if I'm the person using them, we'll just move on to somebody that's got more competence, at least the next time. So I think the market pretty much weeds that out, and Senator Kreun's right. I don't think there would be a lot of attorneys that necessarily would, but there are attorneys can transact real estate the same as realtors right now, and generally speaking, go through as much training on the legal side as probably realtors. So my intent would be just to have parity or the similar practice that we allow today with selling real estate. Most people go to realtors to do it, but in some cases they go to private attorneys and they put up the auction, or they advertise it and transact it for an estate. And so that would be my intent, is just kind of stay consistent with what current law already allows. I guess subject to the committee's intent, but I thought the answer was going to be yes when I asked originally, just assuming it would be consistent with state law and the practice of transacting real estate, which attorneys and auctioneers are allowed to do. So I guess if that brings any more perspective, but if Senator Westland brings a good point. I mean, attorneys do have ethical rules, and if somebody's not coherent in the process, it would be, frankly, a professional responsibility complaint that could be made against them, just like a realtor that maybe is over their head in what knowledge they have if they haven't kept up on some processes. So I don't know if that gives you any more comfort or thought, but it probably would be resolved through ethics complaints if somebody was not coherent in what they're supposed to do as an attorney. That's a license requirement we all have to live with.
Madam Chair.
Senator Kreun.
Thank you, Madam Chair. Upon further reflection, I would probably want to consult with the Bar Association before I make a specialist by their designation into the statute books about whether or not they can do something. So I think this should either be licensed attorneys included or licensed attorneys not included. I think that should be the binary choice for the committee. I'm just not comfortable with my suggestion, as creative as it was, without consulting the Bar Association on that. As to Senator Westrum's and Senator Limmer's points, I think it's important to keep in mind that there are market factors at play here too. The foreclosing lender is going to select the PSO, and if the person isn't competent, they're not going to get any repeated business if they screw up a sale and they have to start over. That's going to not make the foreclosing lender very happy. So I think regardless of which way we go, this would be successful. And again, if whether the committee wants to include licensed attorneys or not, that would be up to the committee.
All right, we have some language from Ms. Primo, I believe. Go to you, and then I'll get your thoughts, Senator Westrum, if you want to continue to move that amendment. Ms. Primo.
Madam Chair, members, I think this is maybe the direction that most of the comments seem to be going. Page 6, line 25, after is, insert an attorney, comma. Page 6, line 26, after 82, insert comma, after 330, insert comma.
Senator Westrum.
Madam Chair, I think that accomplishes what I'm doing, and I think that would just stay consistent with the current practice of transacting or selling real estate for those that want to do. I would move that amendment, Madam Chair.
Okay. Senator Kreun, your position on the amendment?
Vote your conscience.
All right. Any discussion, members? Senator Westrum moves the amendment as described by council. All those in favor say aye.
Aye.
Opposed? I'm in doubt, so I'm going to have folks raise their hands. All those in favor say, raise your hand. Okay, and then opposed, if you can raise your hands. All right. The motion does not prevail and the amendment is not adopted.
Madam Chair, can you announce the vote, please?
Okay. There were 5 opposed and 3 in favor.
All right, thank you. And I assume you saw my hand was up, but.
Yes, Senator Westrum, thank you. All right, are there any other questions on the bill as amended? And the intention is to send this to the floor? All right. Senator Kreun moves that Senate File 4747 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Any opposed? That motion prevails and Senate File 4747 as amended is sent to the Senate floor. Thank you, Senator Kreun.
Thank you. Thank you.
Senator Pappas, are we starting with Senate File 4409?
Yes.
Okay.
Thank you, Madam Chair and members. Senate 4409 is really about compassionate release. It expands Minnesota's conditional medical release framework to include geriatric release, family caregiver release, and extraordinary and compelling circumstances. It adds enforceable timelines, written decisions, a court review backstop, and public reporting requirements. So why does it matter that we need a bill like this? Minnesota's prison population is aging and correctional health costs are rising. The bill's goal is to create a clearer, more accountable review process for cases where continued incarceration may no longer meaningfully serve public safety. Proposals grounded in public safety, fiscal stewardship, transparency, and human dignity. It's not an automatic release bill. It preserves individualized review and public safety analysis by requiring timelines, written denials, and legislative reporting. Bottom line is it addresses a necessary policy problem. And Madam Chair, we recognize that this bill still needs some work with the Department of Corrections, but we really wanted to begin the conversation with the Senate. And I'd like to ask if you would give my testifiers a few minutes to explain what the problem is, and then I anticipate the bill will be laid over. Well, we can start with Darla.
Hello, good morning.
Okay. You wanted to start with testifiers before going to any of the amendments?
Yes.
Okay, sounds good. You can proceed.
Thank you. Good morning, members of the committee. Thank you for giving me the time and space to testify today. I remember a year ago sitting on my bunk in my prison cell, watching the legislative hearings on my 15-inch TV, thinking that I'm going to be in these rooms one day, and here I am. My name is Darla Holland, and I am here in strong support of SF 4409, the Compassionate Release Bill, also known as Tracy's Law. This bill is not the whole solution, but it is a critical step forward. It creates something that we do not currently have in a meaningful way, a real structured opportunity for people to be reviewed, not automatically released, not excused, but reviewed. SF 4409 expands access to people under compassionate release that are aging and have served significant time, who are seriously or terminally ill, and facing extraordinary family circumstances. And this requires a rigorous review process that includes public safety risk assessment, the nature of the offense, institutional conduct, victim input, and verified medical conditions. If someone is at risk, they are not released. And if they are released, it is conditional, supervised, and can be revoked. There's two stories I want to share with you. First is Tracy's story. I want to tell you why this bill matters and why it carries the name Tracy's Law. I met Tracy sitting in the day room in the Shakopee Women's Prison in 2024. She was frail, sick, and confined to a wheelchair, barely able to spend time outside of her cell. She was in a prison within the prison. Her body was clearly failing. But what struck me the most was that even though she had terminal cancer and a prison sentence that would outlive her illness, she didn't even know that there was an opportunity for release. Immediately, I started working with her and advised her about conditional medical release. Because I was able to connect with her, and with the help of our outside advocacy group, Paul Schnell was able to review her medical release and approve her for release. Without this intervention, she would have died in prison. Tracy was granted that review, approved to go home, and she was able to die with her family next to her. And her husband is here next to us today. She didn't die in a prison cell, but surrounded by her family and her grandchildren. The next story I want to share is about James Ferguson, who is over there. James was serving a life sentence, and in 2006, he was diagnosed with cancer while incarcerated and suffered the ravages of that illness, which were only exacerbated by his confinement, including being wheelchair-bound since 2009. He fought that illness for years, and it finally went into remission in 2014. He was living with multiple severe health conditions as a result of both the cancer and years of incarceration, conditions that the prison simply cannot adequately accommodate, and I've witnessed this firsthand. He was reviewed for medical release in 2014, but he was denied because the criteria of the current policy is simply too narrow and too limiting. He went on to serve 31 years of confinement and was not released until 2023. Today, he continues to live with the repercussions of his illness and inadequate care due to the DOC's limited access to specialty health care, including permanent brain injury caused by a condition that went untreated while he was incarcerated. This has left James with severe short-term memory loss, mobility challenges, and speech impairments. This is why I'm speaking on his behalf today. Had he received proper care before his out date, he may not have lost those abilities. But I do want to point out that despite everything, James shows up. He works on our committee, the Hope Act Committee, and he's committed to helping young people stay safe. He shows up even when it's hard, even when he's sick. And because he is determined to make sure that no one else falls through the cracks, James is a light to our community. Tracy's story should not depend on chance, and James shouldn't have fallen through the cracks. Right now, there are people in Minnesota prisons who are aging, seriously ill, incapacitated, and no longer a meaningful risk to public safety. And the thing is many of them are not identified, they are not reviewed, and they don't even know that they have options. This bill will fix that. It creates a system so that people like Tracy and James are not invisible. This bill also recognizes that incarceration, when it is no longer necessary for public safety, has ripple effects. Families are separated unnecessarily. Children go without parents, and loved ones die alone. Compassionate release allows for dignity at the end of life, family reunification when appropriate, and stability in situations where incarceration no longer serves a purpose. This is not soft on crime. It is smart, structured, and accountable. Cases are reviewed individually, risk is assessed, victims are considered, and outcomes will be tracked. And again, release is not guaranteed. This bill does not ask you to open the doors. It asks you to open the process, to allow people to be seen for who they are today, and to make decisions based on evidence, safety, and humanity. Tracy should not have needed luck to go home and die with dignity. That opportunity should exist for anyone who qualifies by law, not by chance. I urge you to support SF 4409, Compassionate Release, Tracy's Law. Thank you.
Thank you for your testimony. We'll move to Edward Miles.
Yes, thanks. Thanks for having me here. Thank you. Thanks for having me here. I just wanted to say that I miss my wife, first of all. And that,
have to be really close.
that this law should be applied because I had the chance for her to spend time with me at home with my grandkids, loved ones. It was painful for me to see her go to the prison and not be able to touch her and hold her. And it was just so difficult for me to see my wife there, feeling almost helpless and alone. Some days not getting her medication that she needed. Some days just being too tired to really talk to me. Sad all the time. And this outlook gave us hope and gave us a little chance to spend the time with her kids and her mom, Judy, and the family. Did everything. She did everything right. And when we found out she had stage 4 cancer, it was not a long process. It wasn't a long time. It was almost like 2 years. And all of a sudden, it was stage 4 cancer. Then she was sentenced to prison for minimal stuff. But like I said, I believe this law should be passed because everybody deserves a second chance, and not a life, even if it's a life sentence, they don't really have to, it's not a death sentence when you go, you know, and that's what I feel, and that's what I have to say about that. That's all.
Thank you for your testimony.
Thank you for listening.
Members, there's also a letter in your packet about Julie's story, which is another story about somebody who also had stage 4 colon cancer. And then, Madam Chair, if we could just hear from the Department of Corrections about, you know, what their plan is to, you know, work more on this legislation, I'd appreciate that.
Sounds good. We have Commissioner Schnell coming forward.
Madam Chair, members, Paul Schnell, Commissioner of Corrections. I first want to just begin by recognizing the thoughtful intent behind this proposal and the issues it seeks to address. Minnesota, like many states, is experiencing an aging prison population with increasingly complex medical needs. And we understand that incarceration has profound impacts not only on those individuals, but their families and communities in general. These are difficult and deeply human issues, and I appreciate the attention given to this and the willingness of the committee to begin this conversation. At the same time, the proposal before you creates some very complex policy, medical, and legal and operational questions. Expanding conditional release in this way will require careful consideration of public safety, medical standards, and each of these will require complex consideration and review as we develop this type of a model. The Federal Bureau of Prisons does have this very model in place, but they also have a very, very complex set of rules, regulations, and processes that govern it. As currently drafted, there are areas where alignment is not yet clear. For instance, just being able to define what substantially diminishes a person's ability to function is something that will require further consideration. There is a fiscal note that would be required in this that is being worked on, but is not yet finalized. And I would just end with this, that currently the DOC has approximately 1,035 individuals in custody that are over age 55. Of those, 242 have served at least 50% of their sentences. And additionally, 139 are over age 60 and have served at least 20 years. And these were some of the provisions in the bill as drafted. And you should know that since 2023, the Department of Corrections has issued conditional medical releases to 16 people. And one thing about the conditional medical release is that it requires a medical determination that the condition suffered by the person is grave and therefore almost requiring hospice level care. Madam Chair, members, the Department of Corrections is committed to ongoing work in this area, working with community advocates, our medical staff, and others, and looking at other provisions of language that could be built in from other states and the federal government as we go forward. And with that, Madam Chair, I would stand for any questions.
Thank you, Commissioner Schnell. You mentioned that the Federal Bureau of Prisons has some of this framework. Does that include what's proposed, both geriatric release, family caregiver release, and the extraordinary and compelling circumstances?
Madam Chair, yes, all of those provisions are built into the law, but the rule and the policy behind it is very, very extensive.
Thanks. Are there other questions for Commissioner Schnell? Senator Limmer.
Thank you, Madam Chair. Commissioner or Senator Pappas, I understand that the Department of Correction has the authority to release at this time individuals that have medical conditions or terminal illnesses. And so why is this bill needed? And what change does it offer?
Did you want to begin, Senator Pappas?
Madam Chair, I'll offer briefly, and then maybe we could bring Darla back up to talk about it some more. So as Commissioner Schnell mentioned, the current law is extremely narrow. You have to be in hospice pretty much, which maybe means you only have a couple weeks to live. So this would broaden it so that, say, you had a couple months to live, or you had a total debilitating illness where you might still live longer, but you're in a wheelchair, or you're not really able to. You need constant care, and that would allow you to be released. It's very expensive to keep people in prison with those kind of medical conditions. So in some ways, this could save the state money if there are other sources, family care or Medicaid or some other ways that they could be supported in a home-like environment.
Commissioner Schnell.
Madam Chair and Senator Limmer, I think it's a worthwhile question. And one of the things that we're seeing more and more of is the need for really pronounced levels of memory care with our aging population that the prison system simply is not really set up to address. We're also seeing the number of people who end up losing body function completely, quadriplegic and so forth, that are very difficult to manage in the prison system and really require very expensive outside care to come in and provide additional assistance that may be better addressed in a care facility in the community. There's certainly a cost to that as well, but they do not pose a public safety risk. So there are, some of those types of provisions that we think really clearly could be beneficial to both the state, to the population, without impacting or affecting public safety.
Madam Chair.
Senator Limmer?
I heard one of the testifiers give comment about a person that had been in prison for 31 years. That to me tells me that that was a pretty serious crime that individual committed against a victim. And it more than likely was not a property crime, it was a crime against a person. And whenever I hear any concept about early release, I immediately think of the victim, although many of the bills that go in that direction don't talk about victims at all. I did notice, though, on page 2, there is a reference on lines 2.2, in determining release eligibility, among other issues, victim impact statements would be considered. Would that be something that would be in the current time? Would you find the victim's family or the victim himself and get a statement? And then, in comparison to the multidisciplinary panel that this suggests, how much impact will a victim statement have with someone that may have Alzheimer's and the medical conditions, as you state, are not, they're a condition that the prison system just is not equipped to handle. I'm looking for the balance here.
Commissioner Schnell?
Madam Chair, Senator Limmer, as it relates to conditional medical releases, for instance, today, we do engage with crime victims. They are brought in. We collect, their concerns. Oftentimes, when they have a better understanding of the medical condition, there is not opposition, or if there is a level of care that's necessary. And we're very mindful about where releases take place, and we want victims to be fully aware of that. But I think one of the things that we hear most, commonly is that they simply do not want the person to pose a risk to public safety. So yes, victim input is very much considered, and we want that to be a balanced approach. And certainly if there are concerns about public safety or risk to victims, we would never grant a conditional medical release.
Just to follow up on that, Commissioner Schnell, I assume that in those situations where you do grant release, there's some notification to victims or family members, whoever you can access.
Madam Chair, that is correct. Always they're aware, and we want to avoid if there's the risk of incidental contact if that person is still ambulatory, which oftentimes they are not.
Thank you.
Madam Chair.
Senator Limmer?
Just one last question. I know that victim impact statement is considered. I do not see any desire in the bill to talk to prosecutors or law enforcement that had been involved in the prosecution. Is that something that's intentional?
Darla, do you want to talk about that?
We didn't.
Ms. Holland?
Thank you. We didn't talk about that specifically being in or out. However, I would say personally, I don't think that should be a provision, because if a person has served a long amount of their sentence, I mean, the Department of Corrections is going to have more awareness about the changes that they've made, and if they're a public safety risk than, say, someone that investigated the crime or prosecuted the crime 30 years ago. So that wouldn't really make sense, and it'd kind of be putting more work on prosecutors that are already overburdened.
Well, Madam Chair,
Senator Limmer.
what if the time frame was 5 years ago?
I still think,
Ms. Holland.
I still think that the Department of Corrections would have a better idea of where a person is at and if they're ready for release. And the Department of Corrections would also be collecting the victim impact statement and notifying the victim.
Madam Chair.
Senator Pappas.
Madam Chair, since this bill is still a work in progress, we can certainly consider that down the road and talk to some prosecutors about it.
Thank you.
Senator Holmstrom.
Thank you, Madam Chair. Commissioner Schnell, I've heard a couple times the question, or rather an answer be raised, that they're not a threat to public safety at this point. And I guess I'm just trying to understand, what is your position on the purpose of having people in prison to begin with?
Commissioner Schnell.
Madam Chair, Senator Holmstrom, certainly it is about accountability and public safety.
Senator Holmstrom.
Thank you, Madam Chair. So that's, I guess what I'm trying to get at here is the justice system and specifically imprisonment. It's very hard to go to prison. You have to clearly separate yourself from society by your actions. It's the reason we've created these places. It's the reason we put them there. And it's not just for the purpose of public safety. It's also as a deterrence and for punishment. I mean, these are real things. And I know that we're talking about cases where people they have cancer, and I get that. But this bill is also addressing non-medical release and geriatric release. And again, if somebody has proven to society that they don't want to be part of civil society, I think we need to accept that. I think we need to listen to them, and I think we need to allow the punishment implemented by the courts to be seen out. I understand if it's a medical release and there's a reason that it's not cost effective in hospice, that makes perfect sense to me. Send them to a care center where they can be patrolled correctly. But just expanding this to, I mean, this is a pretty broad expansion. I think it's missing the real purpose of why we have prisons to begin with and why we have these punishments. That's all. Thank you.
Ms. Holland.
But I think that it's been proven that incarceration doesn't necessarily deter crime for the person incarcerated or for people that are going to become incarcerated. It's about rehabilitation and about, are you a public safety risk? Have your risk needs been met? Have you addressed them? Like, time doesn't necessarily equal if you're ready to be back in society. It's really what you've done with your time, and then other things like aging or medical issues. So that's, I guess, what I would have to say to that. And that's why there are other pathways for release, like we have the challenge incarceration program. While someone might be eligible for the challenge incarceration program and take 3.5 years off their sentence, but they physically can't do it because they might be missing a leg and cannot work in the prison or do certain programming. So are they not they can't be rehabilitated? So there's other pathways, but some people can't access those pathways or work release because they're 65 years old and they might not be able to find a job. They've been incarcerated for 20 years, so maybe being considered for a different type of release.
Madam Chair.
Senator Pappas.
Madam Chair, I just wanted to say a couple of things. Is one about punishment and rehabilitation and compassion. Is that I think those are all part of our system as a civil society, is that there's a certain amount of punishment, but then we really, at some point, most people are going to be released from prison, and we want them prepared to re-enter into civil society. So that's part of rehabilitation. In some cases, the punishment and the rehabilitation may happen, but the health of the individual does not enable them to really, be able to, like Ms. Holland said, to be able to kind of do work release or other programs. And especially when the health is debilitating, so it's increasingly bad. So I think in most cases, this will be people who have served significant years in prison. We're not talking about other early release programs. We're really talking about situations where it's a compassionate release.
Senator Holmstrom.
Thank you, Madam Chair. So Senator Pappas or Commissioner Schnell, who's going to bear the cost of the medical expenses for these individuals when they leave? Is it still Department of Corrections? That's, I imagine they're still under the purview of the Department of Corrections. Is that correct?
Commissioner Schnell?
Madam Chair, yes, they are still subject to commitment to the Commissioner of Corrections, even while they're on a supervision status. But as a for instance, they would go into a specialized care setting for like memory care, very similar to what happens in the community where the services are specifically tailored to the needs of that individual. Unlike the prison system, which doesn't have the capability of managing that, direct type of care need on a day-to-day basis.
Senator Holmstrom?
Thank you, Madam Chair. Senator Pappas, if an individual is served, they're given a 40-year sentence for whatever reason, they're in there for a long time, and they're in their 80s, they're still able to walk around, they're still able to communicate well, and be a normal, fully functional member, would they be eligible for release just on the basis of being old?
Senator Pappas?
Madam Chair, that's really to be determined during the next phase about what would be the criteria, whether that person would be eligible or not. I don't know. I think that's part of the discussion is, a 40-year sentence is pretty long. And usually we do allow a third off for good behavior and other circumstances. So I don't know, maybe Commissioner can tell us how many people in prison they still have in prison that are over 80. Plus, it's a rough life in prison, and you come in with already probably health conditions. People may be chemically dependent, they may be smokers, they may not have eaten well and exercised well, gone to the doctor, so they already probably have a lot of health conditions. So I would be surprised if there's very many that are still in prison that are over 80.
Commissioner Schnell?
Madam Chair, unfortunately, we are seeing that number grow, and we have a larger population, probably around 30 or so at Faribault, that are in that situation. We see our costs going up, oftentimes for outside emergency medical care, at significant cost to the state, where we're transporting them, some instances helicopter flights and those sorts of things out of that facility. And so it's a growing need, not just in Minnesota, but across the nation around the aging prison population and the challenges related to that. And oftentimes you can find cheaper care and more effective care in the community. And I think that's the key thing here is finding that balance of trying to manage public safety, costs, accountability certainly is a part of that. And I think that's the sweet spot that we'd like to find, and that's not present in the bill as it's drafted today. But it's something I think that the Bureau of Prisons has done a good job of through really comprehensive policy development. And along with oversight of Congress setting and establishing that framework. And we think that that's possible here, but not as it drafted.
Yep. Senator Holmstrom?
Final remarks. Thank you, Madam Chair. So, Senator Pappas, you mentioned a few things that I think are worth reiterating. Number one, prison isn't fun. It is a deterrence. I don't think it's fair to say that prison isn't a deterrence. It's why we've done them for as long as society has existed. However, you mentioned that we already have programs in place. We offer a third off your sentence if for good behavior. There's already opportunities, and without clear framework, without a real, other than the savings to the state financially, a societal reason for doing this, I don't see why we'd move forward with this bill. We have the opportunity for hospice. We have the opportunity for all these other remediations. I don't see a value here, and I suppose we'll have more conversations as this bill comes forward again. But I think it's worth tabling for good. Thank you.
I will go to you for some closing comments, Senator Pappas. I think we've had a good discussion. I know that Senator Limmer did have his hand raised earlier. Go ahead, Senator Limmer.
Thank you, Madam Chair. One thing I might want to say is I am in favor of compassionate release. Devil's in the details, as always. I noticed that in the opening statement describing the bill, it talks of non-medical release. And yet, the only part of non-medical release that I can see in the bill is subdivision 2, starting on page 2, line 10. And that recognizes an incarcerated person who has someone at home that they may be able to offer as a caregiver to that individual. But in this case, there's no victim impact statement required. And as we talk about this and lay the bill over, I would suggest that that may need to be included in that. Also, on the third page, on line 310, we don't make a specific reference to subdivision 2, the family caregiver release, but it's broadly spoken as a non-medical release. I hope we're talking of the same thing and not a broad category of non-medical release that has no definition. Perhaps put subdivision 2's title into that spot and remove the non-medical release request. I'm sure there'll be other points that we can talk about later, but since this is being laid over, I think it's best to really fine tune it. And overall, there is a need for it, just from a management perspective from the Department of Corrections. Having worked in prisons myself, prisons just don't offer the physical requirements that people that have medical conditions require. They're limited. And I can get into the mental health issue too, but I won't spend any time on that. I've certainly spoken about that enough over my time here, but yeah, let's keep working on it. Thank you.
Thank you. Go to you, Senator Pappas, for some closing comments.
Thank you, Madam Chair. And I just really want to thank the committee for your insightful comments. And we hope to continue the conversation with a different author.
Oh.
Thank you.
All right. With that, the bill's laid over. Okay. Senator Pappas, we can move to, I think you need to take a brief break here. We were going to move to Senator Maye Quade's bill next, if that works for you. All right.
We're waiting on Senator Maye Quade to arrive, then we'll get started. All right, Senator Maye Quade, we are ready for your bill, so come on forward. Senate File 3210. And if your two testifiers want to join you at the table, Alicia Lane and Jillian Nelson, you can come forward as well. Members, the plan on this bill is to advance it to the floor from here. This is the first stop for the bill, and there is an A1 amendment in the packet, which is a delete everything. So this is going to be in the nature of an author's amendment. Senator Westland moves adoption of the A1 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Maye Quade, we now have the A1 amendment in front of us. I want you to go ahead and describe the bill for us.
Thank you, Mr. Chair and members. Thank you so much for agreeing to hear Senate File 3210. This bill would enshrine reasonable accommodations and Section 504 protections into the Minnesota Human Rights Act. I introduced this bill last session to acknowledge the fears that many in the disability community and people who love people in the disability community have had and continue to have about the rollbacks we're seeing in disability services, rights, and protections. At the federal level, there's been a concerted effort to roll back diversity, equity, and inclusion initiatives, which are themselves disability inclusion initiatives, and cuts to funding for critical services and programs. Here at the state level, we've been asked, against my rabid objections, to balance a structural deficit that exists purely because more people need services as they age, to balance that on the backs of Minnesotans with disabilities, whether it's students in special ed or adults who need services. Senate File 3210 is a simple bill that says any person or organization that chooses not to engage in the process to determine an accommodation requested by a person with a disability may be an unfair discriminatory practice and should be considered if enforcement action is sought out. This language in this bill is nuanced. It recognizes that not every refusal of accommodations is inherently discriminatory, but it still allows enforcement authorities to consider this information in a case where discrimination is alleged. In a 2024 survey of employees with disabilities, 74% reported that their accommodations requests were denied without recourse. This bill will help provide an avenue of remedy. People with disabilities are part of our state and beloved members in our communities. The efforts to exclude and roll back the services that allows people with disabilities to live independently and with dignity is wrong, and I'm really glad we're hearing this bill today. I also want to say I know we are in the Judiciary and Public Safety Committee today, but I invite you all at any point in time to listen in at the Human Services Committee, where we predominantly have these conversations. I might be biased because I serve on that committee, but it is the most interesting committee and the most important work that we do at the legislature, making sure Minnesotans who are often vulnerable to structural violence can live independently and thrive as the people they are. I'm really proud to carry this bill and honored by the trust from the advocates to carry this bill across the finish line in the Senate, and I urge your support. Thank you, Mr. Chair.
Thank you, Senator Maye Quade. We'll turn to testimony now. I have Alicia Lane as the first person on my list, so we'll start there. Go ahead and introduce yourself for the record and proceed with your testimony.
Sure. My name is Alicia Lane, and I'm the Government Relations Director for the Minnesota Commission of the Deaf, Blind, and Hard of Hearing. Chair Latz, thank you for the opportunity to testify in support of the author's amendment for Senate File 3210 to clarify that the failure to engage in the process to determine an accommodation may be considered discriminatory. Please do see my packet, my letter in your packet for additional information. I want to share with you all now that one of the most frequent concerns brought to us by deaf, blind, and hard of hearing Minnesotans has to do with this specific failure to engage in the process of determining accommodations. One example of these situations is where consumers are being forced to use video remote interpreting, VRI, even when an on-site interpreter is necessary for effective communication. So this means that instead of a living, breathing human being with exhaustive training to accommodate a wide range of vision, hearing, and tactile needs, that consumer is given a contraption that's basically a screen and a camera on wheels that needs a lot of babysitting. I like to refer to this as interpreter on a stick. I'm going to give you just a few examples of real life situations that I hear from our community. So one example is a deafblind patient that was refused an on-site interpreter and offered only this VRI option, even though their low vision means that they cannot understand sign language on a two-dimensional screen. If there were an interpreter present in person, they would have been able to optimize positioning and lighting and provide tactile interpretation. Another example is a deaf patient that was in labor and just about to give birth, and despite being generally unable to sit up and look at the screen, she too was denied an on-site interpreter. Really, most of this VRI equipment cannot be adjusted at all in a way to make it even be seen comfortably or at all by someone who's lying down. Similarly, a patient with neck injuries lying in a hospital bed, unable to turn their head even to see the VRI screen, was also denied an on-site interpreter. These denials happened despite on-site being interpreters long being considered a reasonable accommodation. We need this statute updated to clarify that providers must listen to and engage with consumers when determining which reasonable accommodation is, in fact, effective. So please support Senate File 3210 as amended. Thank you all for your time.
Thank you for your testimony today. Jillian Nelson.
Good morning, Chair Latz and committee members. My name is Jillian Nelson, and I am the Policy Director at the Autism Society of Minnesota. I am also a disabled adult. It was not until 1973 and the 504 Rehabilitation Act that people with disabilities had basic civil rights to access public services. It's now 2026, and Minnesotans with disabilities do not yet have the right of accommodations guaranteed in Minnesota statute. Senate File 3210 can change that. It protects individuals with a wide range of impairments, including those that are temporary or managed by medication. It establishes that people with disabilities have a legal right to access programs. It prohibits discrimination in hiring and employment, requiring employers to offer reasonable accommodations. It upholds promises that were made to people with disabilities decades ago that are currently under attack in the current federal political theaters. Promises that in our state are nonpartisan and just common sense. People with disabilities are valuable members of our community. Our culture as a state is not one that would allow us to leave Minnesotans with disabilities unprotected and without civil rights. Access to accommodations is about more than convenience. It is the gateway to live independently in the community. Without accommodations, we lose access to education, healthcare, transportation, employment, and more. Without accommodations, we increase dependence on social services, we decrease self-direction, and inevitably, we return to the antiquated systems of mass institutionalization. Senate File 3210 has the potential to do more than just uphold promises. It has the potential to open up many doors for people with invisible disabilities who often have to fight to receive basic accommodations that are not explicitly outlined in the ADA. The DE amendment or the A1 amendment for 3210 creates an expectation that there is a process to request accommodations, not simply a one-size-fits-all checkbox for public services to be considered accessible. We have long, as a state, been a role model for this country in disability rights, and this once again gives us a chance to be a catalyst and lead the way for other states to codify 504 protections at a state level. Minnesota has a chance today to make sure that citizens like me, do not have to live in fear that a court in Texas can rule against the 504 Act, and in a single moment outside of my own home state, I lose all my basic civil rights. I rewrote this sentence a dozen times, trying to accurately quantify the feeling of living in the shadow, waiting for that decision. The fear, the uncertainty, to know that the life I have fought for could go instantly back to an institution, because we trusted that federal law would be enough to protect us here in Minnesota. I don't know how to explain it. And even more, I don't know how I would explain it to the countless people with disabilities in our community that have no idea right now that this could be happening. So today, right now, let's make sure we don't ever have to tell those who are most vulnerable in our community that they no longer have the right to accommodation, that no one has to include them, educate them, house them, treat them, support them. Let's make sure we never have to tell them that they do not belong. Please support Senate File 3210. This may very well be a piece of legislation that we never actually need to depend on, but it also might be one of the single most important things you do in your career. Thank you.
All right, thank you for your testimony. We'll now open up the floor for questions or discussion. I think maybe I'll start it off because I'm reading through the A1 amendment, which is a very different approach to addressing the concerns of the lawsuit and the viability of Section 504 of the Rehabilitation Act than the underlying bill as introduced. So I'm wondering if Senator Maye Quade, if you can help me understand why the change in tactic here or the method of addressing the problem. Senator Maye Quade.
Thank you, Mr. Chair. So this, I will be very proud to say, my chief author in the other body, Representative Hicks, has really been leading the way in disability rights overall, but certainly on this bill. And as this has moved through the other body, this amendment reflects both the work that they've done over there on their bipartisan bill and also the input of our council here to make sure that it's achieving the goal we want it to achieve in the simplest and cleanest way.
So I understand the desire to try to line things up with the other body, but of course, we have to do what we think is the right way to address the problems here in the Senate, and there'll be ample opportunity to line it up later if we need to. I mean, I'm looking at the materials in Section 504B and the case that's involved. It just looked to me like, as introduced, was a much more direct way within the substantive content of the statute to address concerns relating to disability, which I believe was already in many ways prohibited in the Human Rights Act. So I'm a little surprised that there's even a question here about this. But then the DE amendment adds to the public policy statement, not to the substantive portion of the bill. It makes, on lines 25 and 26, a statement about the purpose of accommodations, and then it has one sentence which is equivocal in the way it's written. The failure to engage in the process to determine an accommodation may be an unfair discriminatory practice under this chapter. I mean, so I'm wondering, why is it written equivocally, and why isn't that statement in somewhere in the substantive portion of the statute rather than just in the public policy portion, which is, we don't usually do, but the Human Rights Act has had one for many, many years, intended as guidance, general guidance to the public and the courts when they're interpreting the statutes. Is that all you're really trying to do here, is give guidance to some court in the future when they're interpreting the statute that reasonable accommodation might fit under an unfair discriminatory practice? Senator Maye Quade.
Thank you, Mr. Chair. And I will fully acknowledge that accommodations are a delicate balance between a person with a disability and whoever is requesting accommodation. And so there's not a rule that says that accommodations must happen, and that's why we have landed on May. It's the refusal to participate in the process that would be deemed discriminatory, not necessarily the outcome. And I think what you've heard from the testifiers is that the process itself is actually very important, that people have access to requesting that accommodation, and instead of just getting a no and then the process ends, engaging in why that conversation is needed and why that process is needed. And so that's how this bill has been written, to actually match that intent. The previous version, I don't think, matched that intent. And so we put it actually where we intended it to be, although I know the Senate's aversion to policy statements. But yes, you're right, it's been in the Human Rights Act for a long time.
Senator Maye Quade, help me understand why a failure to even have the conversation about reasonable accommodation isn't already a discriminatory act under the Human Rights Act. Senator Maye Quade.
Thank you, Mr. Chair. That is a great question. I don't know if I have a really good answer to that, but I think it's part of because the way that the statute is written right now, accommodations, they're just required to hear it, and the process itself isn't detailed. And what we've experienced on the ground is that that process is not happening. And so that's why we're more detailing the process and not the type of accommodation required. And for whatever reason, it is not clear enough in law because it's still happening every day, and you know, there's no accountability for it. And I would look at my testifiers to see if I've missed anything.
That's an absolute accurate. I mean,
Nelson.
right now I can go into a place and ask for accommodations, and they can look at me and say, well, we're already ADA compliant. We don't need to have this discussion with you. Well, I'm asking for accommodations for autism. I know this isn't the Human Service Committee, but I'm sure you all know enough about autism to know that it is not a ramp, a bathroom, or a handrail that would be the form of accommodations I would need to participate in many things. I might need things, more information in writing, or a place to take a sensory break, and none of those things are outlined in the ADA. But the ADA allows, like, without this incredibly explicit saying that you have to participate in an interactive process, they can just say, this is what we can offer you, and anything else, sorry, you're out of luck. We need to be able to have those conversations. It does say may because sometimes people with disabilities do request accommodations that aren't reasonable. Like if I were to ask Senator Maye Quade to give me a pony to participate in that hearing, that is not reasonable, and denying that would not be discrimination. But if I were to ask to have closed captioning so that I could follow along because of a verbal processing delay, and Senator Maye Quade was just to say no, that would be what is actually happening in our world. I have a diagnosis of complex post-traumatic stress syndrome, and it is due to the intense and significant fights I have had to make for very, very basic accommodations as a person with an invisible disability. This language would mean that there is specific guidance that interactive accommodation process is required, and would hopefully make our state a lot more accessible for people with disabilities, because it is the expectation that there is a conversation, not just a, well, here's our ramp. We're accessible.
So, Ms. Nelson, I agree completely with you on the need for an interactive process to determine if a requested accommodation is reasonable under the circumstances. I'm just questioning whether the method of addressing that in the Human Rights Act, proposed in the A1 amendment that we have adopted as an author's amendment, is the best, most effective way to do that, rather than simply adding a substantive provision in the Human Rights Act that says, upon a request for an accommodation, the party being requested must engage in an interactive process to determine if that accommodation is reasonable, and if we need to clarify something else as to, you know, what's defined as a reasonable accommodation, if we can, within the Human Rights Act, if it's not already there, or within Minnesota case law interpreting our statute, not the federal law, then my thought is that's where these corrections ought to be made, not in a purpose statement. which frankly, as far as I'm concerned, I'm not even sure it has a real substantive impact. It states a goal. It doesn't, so anyway, I'm questioning the process or the method of remedying this, not the need to remedy it. But maybe I'm the only one who's thinking this way. We'll see if anyone else on the committee. Senator Maye Quade, did you want to respond? Then we'll open it up for the floor.
Thank you, Mr. Chair. And I absolutely hear what you're saying. I think, you know, if you look at the bill as introduced, it talks about an entity must provide reasonable accommodations and ensure no individual with disability is discriminated against by that entity. And really, you know, what we're seeing is that it's the process of engaging about that accommodation where things are falling through the cracks. And so detailing that accommodation process and the engagement in it as part of the goal, I think is more important than just saying, you know, they must provide reasonable accommodations. Where that still leaves us is a place where the entity said, you asked, I said no, and so this is done. And engaging in that process is ideally the better way to handle this.
Any members of the committee have any questions or discussion? Senator Kreun.
Thank you, Madam Chair, or Mr. Chair. My apologies.
By this point in the session, I've been called everything, so.
Sorry. I think I'm understanding where Senator Maye Quade is going with this, with the A1 amendment, which my only issue with the A1 amendment is the policy statement, but that whole section is littered with, I mean, it is a policy statement. But having said that, I don't know why we need to add to that. So there's a relatively easy way to reword this new subdivision 1C so that it isn't a policy statement, but still uses the same language that's in the A1. And I don't know if this committee would be open to doing that, or are we just going to go with the policy statement because that's what's been done in the past?
It's up to a majority of this committee what direction we go.
Well, thank you, Mr. Chair. Then I will offer an oral amendment to page 1, line 25, I guess it would be of the A1. Delete paragraph C and insert a new paragraph C as follows. Failure to engage in the process to determine an accommodation to allow people with disabilities to participate fully in employment, housing, and real property, public accommodations, public services, and education may be an unfair discriminatory practice under this chapter. Uses the exact same language, Mr. Chair. It just doesn't put it in the form of a policy statement, which if I had more energy, I would have rewritten the whole thing. But I don't.
Can we get Senator Kreun some coffee down there, please?
Mr. Chair.
Or maybe not. No. Senator Maye Quade.
Thank you, Mr. Chair. And I think, Senator Kreun, you've done a really good job of putting that back together with the same language in a way that makes perfect sense, and I would be more than happy to accept that oral amendment. I also think the statute that we originally were amending before is about service animals primarily, and so I think there's a tendency, there might be a tendency to look at that statute and say like, well, I have to provide you a process for your service animal, which is why it wasn't like the best place to put it. So I would take your oral amendment, Senator Kreun, and I think you're doing just fine without coffee.
Could we, I was trying to catch up in my handwriting here, Senator Kreun. Could you restate that, please? Because you changed a little bit about the wording in the second sentence in existing paragraph C.
Thank you, Mr. Chair. Page 1, line 25, delete paragraph C and insert a new paragraph C as follows. Failure to engage in the process to determine an accommodation to allow people with disabilities to participate fully in employment, comma, housing and real property, comma, public accommodations, comma, public services, comma, and education may be an unfair discriminatory practice under this chapter.
Ms. Primo, do you have any thoughts on this proposed amendment? Nothing to add? I have a question, Ms. Primo. In your professional judgment, is amending the policy statement in Chapter 363A.02, would that have the substantive effect that is desired by the advocates for the legislation? Or is it simply a suggestion for courts as they interpret things? Or am I off completely? Ms. Primo.
Mr. Chair and members, my understanding of maybe the goal with the A1 amendment is to provide some indication, some basis for adding a layer to what is currently an unfair discriminatory practice under Chapter 363A. And that the goal is to add that through a policy, sort of, not a policy statement, but something that clues others into the interpretation of how a failure to even engage at the outset could be an unfair discriminatory practice. And if that is the goal, then the A1 amendment or Senator Kreun's oral amendment achieves that. If the goal is something different than that, then there may need to be further substantive changes to the underlying chapter.
Is there any further discussion on Senator Kreun's proposed amendment? Senator Maye Quade, you were treating this as a friendly amendment, as I understand?
Yes, Mr. Chair.
All right, we'll take a vote on it. All those in favor of the A1, of Senator Kreun's amendment to the A1 amendment, I'm sorry, all those in favor of Senator Kreun's amendment, say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Is there any further discussion on Senate File 3210 as amended? Is there a motion? Senator Pappas moves that Senate File 3210 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. 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 Opposed? Motion prevails.
Aye.
Oh, sorry, Senator Westrom. Thank you.
Thank you.
A motion prevails. Next up, Senator Pappas, Senate File 1995. And I see we got some testifiers coming up. If Tom Brace and Ray Bolger are present, come on forward at this time. Members, the packet is being distributed to you. This is the Committee of First Jurisdiction. There is a 2 amendment in the packet.
Mr. Chairman, I'd move the A2 amendment.
Members, this is an author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Pappas, tell us about your bill.
Thank you, Mr. Chairman. House Senate File 1995 is a simple bill to help the fire suppression industry, their customers, and the State Fire Marshal Division. The bill in front of you transfers funding from the general fund to the State Fire Marshal's Division to increase fire protection staffing, to reduce turnaround time, as well as the time for plan reviews and inspections by moving the funds received from sprinkler permits, license certificates, and fines from the state general fund into a dedicated account where they were intended to go originally, to be used solely to operate the State Fire Marshal Fire Protection Program. The amendment that you adopted also adds the fees collected in 299M.1111 to be transferred to the dedicated account at the State Fire Marshal Division. The funds come from the sprinkler industry fees. In fact, the industry initiated the statutory language, as I mentioned, and the fees with the understanding the funds would be used for the purpose we seek today. Permits account for about half the revenue, while surcharges, licensing, certifications, and registration account for the rest. The total 2025 revenue was about $600,000. The bill has been shared with DPS State Fire Marshal Division. They have no objections and are neutral, and I'll turn it over to my testifiers.
Thank you. Who wants to go first? Go ahead and introduce yourself.
Chair Latz, Senator Pappas, members, my name is Tom Brace. I am the former Minnesota State Fire Marshal. I was the Fire Marshal from '87 to 2003. I'm a fire guy that is a sprinkler advocate. I currently serve as the Minnesota State Coordinator for the National Fire Sprinkler Association. I was the State Fire Marshal when the fire protection system was created in 1992. It called out for 5 plan reviewers, a supervisor, and a clerical. Today, this program still has 3 plan reviewers, inspectors, a supervisor, and a clerical. Just think of all the buildings constructed since that time that have been built and were sprinklered. Many of these new buildings were residential. Unfortunately, it can often be difficult for contractors to get the work done on time. The program, when it was first constructed, envisioned 2 to 3 week turnaround time, but sadly, the time has been as long as 12 to 16 weeks. You'll hear from a sprinkler contractor the difficulties when a plan review inspection takes a long time to be completed due to the State Fire Marshal staff shortage issues. One partial solution to this problem is the use of fees for service model already found in state government, and in particular at the Department of Labor and Industry. This will move the fees paid by the sprinkler industry out of the general fund to the specific public safety purpose intended. As you heard Senator Pappas say, the amount is approximately $600,000. This is the right thing for the sprinkler industry, the contractors, the builders, and the citizens of the state of Minnesota. Thank you.
Thank you, Mr. Brees. Glad to have you back here in front of the committee.
Thank you, sir.
Mr. Bolger.
Good morning, Chair Latz, Senator Pappas, members. My name is Ray Bolger. I'm here today as the chair of the NFSA Minnesota chapter, as a general manager of Ahern Fire Protection, which is a local fire protection contractor, and as an active firefighter. Thank you for the opportunity to testify today. I'd like to offer the perspective of a fire protection contractor. As an industry that is entirely driven by codes and standards, we rely on clear interpretations and timely plan reviews to design, install, and commission systems that protect lives and property. Since 2021, my company has submitted 15 fire sprinkler projects to the State Fire Marshal's Office, totaling approximately $11.5 million in life safety work. Review times on those projects have ranged from an average of 21 weeks across all 15 jobs and up to 32 weeks across the latest 6 jobs, with all durations well exceeding reasonable timelines. These delays cause serious problems. First, during design, we often receive limited or no response when seeking guidance on code interpretation. As a result, plans are submitted without any collaboration at all. Second, notice to proceed, critical for keeping projects moving, are frequently delayed. On 12 of the 15 jobs, we have been forced to begin installation without a notice to proceed simply to avoid delays and fines. We completed 8 projects entirely without any approved plan reviews. We've also experienced missed inspections, deferred inspections, inspections requested by video, or inspections shifted to local authorities, sometimes resulting in duplicate plan review fees as a result of plan reviewers indicating limited availability. Next week, we will finish another large project in Lasora, Minnesota, without a completed plan review. The risk to contractors and owners is enormous. The State Fire Marshal's Office retains the authority to require changes even after a system is installed. When that happens, it costs money, causes delays, exposes us to damages, and makes competent contractors appear negligent to building owners. This also impacts the owners who may already be occupying the building and running businesses. I strongly urge you today to support SF 1995, this legislation to direct permit and license funding to the State Fire Marshal's Office so it can be properly staffed and deliver timely plan reviews and inspections. Thank you for your time.
Thank you, Mr. Bolger. And for the committee's information, the intent today is to lay the bill over for further consideration. That's correct, Senator Pappas?
Yeah, Mr. Chairman, also there's a letter in your packet from another individual from a fire sprinkler company, also talking about how the delays have impacted their ability to move forward with projects, or they've had to complete projects without the plan review and just hope that everything's okay. So with the amendment, we're kind of splitting the money now. So the penalties would still stay in the general fund, but the fees would go to the State Fire Marshal Division to help them hopefully add additional staff so that they would be able to do these plan reviews in a more efficient manner.
Any discussion or questions from members of the committee? I'm not seeing any. Senator Pappas, thank you.
Thank
Senate
you.
File 3210 as amended is laid over.
Thank you.
I'm sorry, I had the wrong Senate File number. Senate File 1995 as amended is laid over.
Great, we will go to Senator Latz, Senate File 3290.
Thank you, Madam Chair and members. Senate File 3290 would establish the Organized Retail and Supply Chain Crimes Advisory Board. As you may recall, in recent years, we have identified organized retail crime and supply chain crime as a serious problem in Minnesota. We've taken steps to address it, but we want to take the next step here to make sure that there is ongoing review and oversight and guidance on how to solve this problem, which is growing within our retail establishments and is costing consumers everywhere who have to pay for the increased cost of the losses to our retail establishments. So in support of the bill, we do have a number of testifiers, so I'd ask them to come forward.
Whoever wants to begin, you can just start by stating your name and title for the record.
Good morning, Madam Chair and members of the committee. My name is Bruce Newstead with the Minnesota Retailers. Our members range from small, locally owned businesses to regional and national retailers serving Minnesotans across the state. Chair Latz, thank you for authoring Senate File 3290 along with Senator Limmer. In your packets, a briefing listing 16 organizations, excuse me, reflecting the broad coalition supporting this issue, including retailers, the full supply chain, and labor. Organized retail and supply chain crime is not isolated. It's coordinated, sophisticated, and it's growing. These are not one-off thefts. These are criminal enterprises targeting every point in the supply chain, from warehouses and trucks to store shelves, impacting retailers, workers, and consumers statewide. These criminal operations often operate across jurisdictions and in many cases actually extend beyond the state and national borders. The proceeds from these crimes are frequently tied to broader criminal activity, including drug and human trafficking and sometimes violent crimes. Members of the committee, you may remember, as Senator Latz mentioned, 2023, when this body passed Minnesota's ORC definition. Thank you for that. During that conversation, you heard from Walter Dillon. He was an entrepreneur who invested his family's savings into opening a small shoe store in Little Canada. It was his dream, but he was repeatedly targeted by organized criminal activity over and over again and was ultimately forced to shut down after just about a year of operating. That's exactly the type of crime that we're trying to connect the dots on here with this bill. And we're trying to reach that earlier and before it reaches that point. I want to also briefly just share the experience of a smaller locally owned retailer, Patina, with 8 stores. Karen Tapero, the director of retail operations, couldn't be here this morning, but she previously testified about 2 situations that highlight what this crime looks like in our communities. In one case, a repeat offender targeted multiple stores over time, stealing high-demand pop culture items and selling them online, really working off of shopping lists, which points to the coordinated activity that occurs. And another, group moved store to store, filling bags and escalating threats and even assaulted an employee. In both these cases, the patterns were clear across locations and even beyond Patina, but it was difficult to act across jurisdictions. And that's really a key point. This crime impacts retailers of all sizes and the entire supply chain, which you'll hear about today. And while it is not the fault of law enforcement or prosecutors, too often the system sees just isolated incidents, not the dot connecting that needs to occur. Minnesota, as I said, took an important step in 2023 defining ORC and statute. The challenge now is coordination and execution. Our system remains too fragmented to effectively recognize the enterprise-level crimes that occur. This Senate file addresses that gap by establishing a coordinated statewide approach and an advisory board at the Bureau of Criminal Apprehension. That brings together law enforcement, prosecutors, labor, and industry to share, connect cases, support stronger enterprise-level prosecutions. This is a practical and scalable solution. It starts with better coordination, connecting activity across jurisdictions, and builds over time through training, resources, and enforcement. It's not about creating a new bureaucracy. It's really about making the current system work better together. We've seen this model work. Minnesota's Financial Crimes Task Force is a strong example, and 17 other states are using similar approaches to address organized retail and supply chain crime with measurable results. Without action, we'll continue to see fragmented responses, more sophisticated criminal networks growing, and increased costs and safety concerns across Minnesota. This bill provides a clear, proven path, and we appreciate your consideration. I'll close with just an invitation. I know the chair had an opportunity to visit a store and sort of see how these crimes are impacting our communities and stores maybe a year and a half or so ago, and we'd invite any of you to see that activity and see how it's impacting our stores and our communities at a store, should you desire. Thank you, Madam Chair.
Thank you for your testimony. We do have a testifier online that we'll go to next.
Hello, can everyone hear me?
Yes, go ahead.
Great, thank you. My name is Adam Ethington. I'm Director of Strategy, Policy, and Government Affairs for the National Insurance Crime Bureau. Very happy to testify on this bill today on behalf of the NICB. We are here in strong support of SF 3290. The NICB is a leader in the fight against insurance crime and fraud, and we encourage the committee to take up and advance this bill. We are backed by approximately 120 property and casualty insurance companies across the nation, including 436 who write business in Minnesota, and we have other partners within our anti-fraud ecosystem. Cargo theft is a significant criminal issue with approximately 455 million in cargo stolen nationwide in 2024, a 27% increase in thefts compared to 2023. Stolen pharmaceuticals and food supplies pose a real health hazard, and these commodities, along with electronics, continue to be the favorite target of thieves. Cargo theft poses a significant health risk to consumers who unknowingly buy stolen food or drugs which have been improperly stored or contaminated as they move through illicit commercial streams, believing that they are getting safe and secure products. Furthermore, cargo theft increases the cost of merchandise, food, and transportation, with consumers ultimately paying the price. SF 3290 recognizes the significant rise in organized retail theft and cargo theft, both statewide and across the country, by establishing an advisory board of subject matter experts to help craft strategies to address these crimes. The bill will benefit Minnesota law enforcement by enhancing their ability to coordinate investigations, and NICB stands ready to provide operational and intelligence support to Minnesota's efforts to combat cargo theft crimes. Thank you for considering our views, and as always, happy to stick around and answer any questions that you might have.
Thank you for your testimony. We'll get through the rest of the testifiers and see if there's questions for you all. You can begin by stating your name and title for the record.
Yes, good morning, Madam Chair. I'm John Houselodden, President of the Minnesota Trucking Association. We're also here in strong support of Senate File 3290. Today's cargo theft is not any longer just physical theft. As you've heard, it's sophisticated, it's coordinated, and it's often international. These criminal groups target both freight and data at every point in the supply chain using tactics that are frankly constantly evolving. Our industry doesn't just move goods. Like I said, we move data. The same technology that helps us operate efficiently also creates vulnerabilities that the criminals are exploiting. So what used to be simple theft, stealing a trailer or hijacking a load, has evolved. Today we see fictitious pickups, cyber attacks, GPS spoofing, and most critically, identity theft. So think about this. In a typical shipment, you have a shipper, you have a receiver, you have a fleet, you have a driver, and often a broker. Those are 5 separate entities that can be and are regularly stolen. Companies now have to question whether they're dealing with legitimate partners or very sophisticated bad actors. So you may have heard about the theft of $1 million worth of tequila linked to Guy Fieri and Sammy Hagar. Well, similar crimes are happening across Minnesota. Our members are reporting losses ranging from $22,000 to $250,000. So just in one case, a member of ours had its identity stolen, and over 7,800 fake loads, it's like a load board where you post available loads, were posted in just 45 minutes. And another shipment was digitally redirected from St. Cloud, Minnesota to Sacramento, California, virtually in real time, without the company's knowledge nor the driver's knowledge. Cargo theft now exceeds huge numbers, 35 billion annually in the United States, and these crimes often cross multiple jurisdictions, as you've heard, city, county, and state. So it leaves our members struggling to find law enforcement support or even determine who has the authority to act, and that is a helpless place to be. That's why this bill matters. This advisory board creates a process that brings together stakeholders to better understand, coordinate, and respond to this growing threat. And I think here's the good news for policymakers. There's no opponents. It's only the bad actors. We have a strong coalition of business, labor, and groups all along the supply chain. So we ask you to support the bill, move it. It's a critical step in protecting our supply chain and controlling costs that ultimately impact every Minnesotan. Thank you.
Thank you for your testimony. We'll move to our last testifier.
Thank you, Madam Chair. My name is Amanda Dewar. I'm the Director of Government Affairs for the Minnesota Automobile Dealers Association, which represents the state's franchised new car dealers. Over the past few years, dealers have witnessed a rise in sophisticated and organized crime. These are not smash and grab crimes of opportunity like shoplifting, but are complex and premeditated. For example, wheel and tire thieves will target dealer lots and place cinder blocks under the stripped wheels so employees don't notice a difference in a vehicle's height. We've also had burglars use glass cutters to gain entry into a dealership, disable the alarm systems, and ransack key boxes, making off with several cars. And our association has been leading an effort in Congress to increase the federal penalties for catalytic converter theft, which is also an area where dealers have been targets of organized criminal operations. Our biggest problem with battling these crimes is a lack of coordination amongst local law enforcement. Well-intentioned and hardworking investigators in individual cities will do their best, but as thieves hop from one community to the next, arrests are hard to make. In short, we need help, and we're asking for the government to provide some basic coordinations in their investigations. We think Senate File 3290 is a great first step, and thank Senator Latz for authoring this bill. Thank you.
Thank you for your testimony. Members, are there any questions for our testifiers? Any questions on the bill? Go to Senator Holmstrom and then Senator Limmer.
Thank you, Madam Chair. Senator Latz, when this topic was brought up in the other body, the chair had said that, or at least referenced that we should conduct a research on the beneficial impact of organized retail theft. And I guess I just want to confirm that that would not be a purview of this advisory board, that they will not be devolved into such nonsense. Is that your intention?
Senator Latz.
Madam Chair, Senator Holmstrom, I've got a quizzical look on my face because I'm having trouble imagining what kind of beneficial impact there would be unless you're a thief seeking to profit from it. It's not the intention of this bill to examine that.
Senator Holmstrom.
And I think that's why we affectionately refer to them as the lower body.
Says a recent grit. Well, you haven't been there yet, have you? Those of us who have been there have a stronger platform for our claims than you do, Senator Holmstrom.
Senator Limmer.
Thank you, Madam Chair. Senator Latz, I'm in support of your bill, being a co-author, but I did have a question on the last page. Page 4, lines, the meat of it is on 4.2. Regarding the advisory board can collect donations, and it states the advisory board's fiscal agent shall handle all funds approved by the commissioner. And I'm just looking at the wording on it. Fiscal agent, I don't know if there's a definition in the bill regarding who that fiscal agent would be. And the word shall handle all funds, maybe perhaps account for all funds, might be a little bit more direct. And then the question would be, would that financial accounting, would that be available for public review or not? I don't know what the classification of data would be on that.
I think I have.
Senator Latz.
An assistant has arrived to answer the questions.
Mr. Newstead.
Thank you, Madam Chair. Senator Limmer, I think our intention there was to clear a path for some industry contribution to the project. I don't have a great answer to your actual question on handle versus hold versus administer, but I'll just say we're certainly open to working out language that would be comfortable in that regard. The intention was, though, that industry might be able to provide some support for the project. And that's about as far as we thought through relative to that language. So there wasn't any real intention behind the word fiscal agent or handle specifically anyway.
Senator Latz, or I'm sorry, Senator Limmer.
Yes, I'm going to ask Mr. Turner to describe in a preliminary report what the role of the Public Safety Commissioner would be, or the department at least.
Mr. Turner.
Madam Chairman, members, this is from the fiscal note, preliminary fiscal note on the House Companion, House File 2879. And it reads, the Fiscal and Administrative Services Division of the Department of Public Safety will act as the fiscal agent for the advisory group, including accepting any grants or in-kind contributions it may receive, and paying, subject to the availability of funds, any per diem or expenses that the advisory board might approve for its membership.
Madam Chair.
Senator Limmer.
That answers my question.
Madam Chair,
Senator Latz.
Do we need to amend any language in the bill here to reflect that?
Mr. Turner.
Madam Chair, I don't believe so.
All right, I'm not seeing any other questions from members, so this bill will be laid over. Thank you, Senator Latz.
Thank you.
We'll move to Senate File 2126, Senator Seeberger. Senator Seeberger, when you're ready.
Thank you, Madam Chair. I am pleased to be here today on Senate File 2126. This bill carries a variety of provisions to recognize and support the courageous efforts of our law enforcement. This bill would establish January 9th as Law Enforcement Appreciation Day, recognizing the hard work our men and women in uniform do to keep communities safe and respond in times of crisis. Additionally, school boards would be encouraged to partner with local law enforcement to provide career exploration for public middle and high schoolers, and those elective courses can be offered for credit. Finally, this bill also appropriates $6 million toward peace officer training assistance and $1 million towards pathway to policing, making it easier for people from non-traditional backgrounds to start in law enforcement careers. I have let's see, is Mr. Potts here? Yep. I have Jeff Potts, Executive Director of the Police Chiefs Association, to provide testimony on this bill, along with Sheriff Eric Wallen from Lyon County.
Thank you. Mr. Potts.
Thank you, Madam Chair. Again, my name is Jeff Potts, Executive Director for the Minnesota Chiefs of Police Association, and I'm here today representing the 315 police chiefs and several hundred command staff officers from across the state. We want to thank Senator Seeberger for bringing this bill forward. We appreciate very much Section 1, which is designating January 9th as Law Enforcement Appreciation Day. I think recognizing the work that law enforcement officers do on a day-to-day basis and the sacrifices that they make to keep their communities safe. That is a great gesture and much appreciated by the law enforcement community. Section 2 is regarding law enforcement explorer programs. We view this as a recruiting tool, but also a community engagement tool, and taking time to help invest in our youth who may someday decide to be a police officer is a great way for our profession to draw more people into it. Section 3 is the peace officer training component. This is a much needed investment. Maybe you know this, maybe not, but there are several required trainings that police officers have to go to throughout the licensing cycle. Those include not only what you might think are kind of the common ones like use of force or firearms training and emergency vehicle operations training. Those are requirements that have been in place for a long time, but more recently we've added required training in the area of crisis intervention and mental illness and crisis, conflict management and mediation, recognizing and valuing community diversity and cultural differences, along with implicit bias training, autism training, and crimes motivated by bias are all required. The cost for those trainings are considerable, and these dollars are greatly needed to help cover those costs, along with all the other training that police officers are expected to conduct on an annual basis. Section 4, another recruitment tool, the Pathway to Policing program has proven to be a valuable and successful way to bring people into law enforcement on a non-traditional path, and we greatly appreciate the continued investment in that. These investments in recruitment and training are greatly needed. We fully support the bill, and again, thank you, Senator Seeberger, for bringing this bill forward. Thank you, Madam Chair, for allowing me to testify here today.
Thank you, Mr. Potts. Gavel's been shifted back here, so now it's Mr. Chair, except for Senator Kreun. I guess I'll still be Madam Chair. Sheriff Wallen, welcome to the committee.
Yeah, thank you, Chair Latz, and members of the committee. Thank you for the opportunity to speak here today. My name is Eric Wallen. I'm the elected sheriff of Lyon County, and I'm here today representing the Minnesota Sheriff's Association, which includes all 87 elected sheriffs in our state. No one enters law enforcement to seek recognition for their service. These men and women have a service-oriented mindset already, and their primary goal is to protect their communities and ensure its safety. Establishing a day to honor their service and sacrifice of the men and women in law enforcement reinforces our support and appreciation of their efforts. One of our main concerns in law enforcement today is the recruitment and retention of our staff, both now and in the future. It is essential to create school programs that provide education and opportunities for students interested in pursuing a career in law enforcement. This initiative is crucial for maintaining the safety of our community and ensuring that there will always be qualified, well-trained law enforcement applicants. In 2018, an agreement was established by the legislature and the law enforcement community. This agreement stipulated that officers would receive essential training in areas such as use of force, crisis management, cultural diversity, conflict management, and autism awareness. In return, the state committed to providing reliable annual funding to support this training. It is crucial that we honor this commitment both in principle and with actual funding. Last session, cuts were enacted that significantly reduced the training fund for the next few years and ongoing years. This was not merely a budget adjustment, it is a retreat in the state's promise and poses a significant threat to equitable access to professional development for our law enforcement officers throughout the state. This impact is especially pronounced in small and rural agencies. Approximately 70% of our law enforcement agencies have fewer than 20 officers. And for many of them, this fund is their only resource for meeting the state's training requirements. Without sufficient funding, these departments will face serious challenges in compliance, preparedness, and public engagement. And as we all know, failing to prepare is preparing to fail. Since 2020, more than 30 police reform bills have passed through this legislature, many of which are dependent on comprehensive officer training. Additionally, recent mandates such as the new requirement of school resource officer training have further increased those training burdens. These reforms cannot be successful without consistent investment. We are not asking for new funding, but rather for the state to uphold the commitment that has already been made. It's also important to recognize the significance of the fund's name. The Philando Castillo Memorial Training Fund was created to symbolize our collective resolve for meaningful change in law enforcement practices. Underfunding this initiative not only jeopardizes training and accountability goals, but also threatens to undermine the powerful legacy and intention behind its name. Ladies and gentlemen of this committee, in 2018, there was unanimous understanding among our state legislatures, law enforcement leaders, and community members that we wanted and expected our law enforcement officers to be more competent, more capable, and better prepared for the dynamic challenges of their job that they do each day, and to ensure that they made good decisions when life and safety depended on it. The formula for that to succeed is very simple. It requires two things: good people and improved and more frequent training. If we do not honor this agreement and maintain the previous commitment to the training fund, we can expect officers to be less prepared, less competent, less confident in their own decision-making and abilities during the stressful situations that they will face each day. That would be unacceptable to the public that we serve and should be unacceptable to all of us here. The Minnesota Sheriff's Association would like to thank Senator Seeberger for bringing this bill forward. And on behalf of the Sheriff's Association and the 87 elected sheriffs in the state of Minnesota, we respectfully ask for your support of Senate File 2162 to increase the appropriation for reimbursements to local law enforcement agencies for training and supporting present and future law enforcement. Thank you for your time and consideration, and I'm happy to answer any questions the committee may have.
Thank you, Sheriff Wallen. Appreciate your testimony and the bill that we have before us. Any questions or discussion from members of the committee? Senator Holmstrom.
Thank you, Mr. Chair. Senator Seeberger, I love the bill. I think this is great. I'm just wondering if we found a funding mechanism for it yet.
Senator Seeberger.
Thank you, Mr. Chair. Senator Holmstrom, that remains to be seen, but I think it's important enough to bring this forward and remind the committee and the people of Minnesota that we made this commitment. And I vividly remember the cuts of last session. And I think it's important to impress upon this legislature, the governor's office, the people of Minnesota, that this is a priority. And I would hope and expect that funding can be found for this.
Senator Holmstrom.
Thank you. I share in that hope. We found already in this year some pretty creative funding mechanisms for things that I don't think are nearly as important as this bill. So I really hope that the caucus can get together and actually fund it this year and make sure that this isn't just more lip service. Thank you.
Any further discussion? Senator Clark.
Thank you, Chair Latz. Senator Seeberger, January 9th, is there a significance for why January 9th was selected as the date for recognition?
Senator Seeberger.
Thank you, Mr. Chair. Thank you, Senator Clark. No. But the date was chosen, and I believe it is an appropriate time. There's cities across the state that have law enforcement appreciation days, law enforcement appreciation weeks, and I think as a state, it is appropriate to carve out a time where we collectively acknowledge the service and sacrifice of our law enforcement officers, and January 9th would be that day.
Senator Kreun.
Thank you, Mr. Chair. January 9th is the National Law Enforcement Appreciation Day. So I think it's very fitting that January 9th should be Minnesota's Law Enforcement Appreciation Day. I very much support it.
Any further discussion? Not seeing any. Thank you, Senator Seeberger and testifiers. Senate File 2126 is laid over.
Thank you.
Okay, members, next up is Senate File 4204, Senator Oumou Verbeten's bill. It is being passed out. Members, this is the first committee stop. The intention is to lay the bill over. After our discussion of it, there is an A4 amendment, which would be in the nature of an author's amendment. Senator Oumou Verbeten moves adoption of the A4 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Oumou Verbeten, tell us about your bill.
Thank you, Chair Latz. Senate File 4204 removes the criminal penalties for the personal use and possession of psilocybin. This is one of 3 recommendations from the Psychedelic Medicine Task Force. I'll note that there are other recommendations from the task force that I certainly support, and they are traveling in other bills, but the bill that we have before us today is really specific to the one recommendation on removing criminal penalties, very much within our committee's jurisdiction. I think it's an important conversation for us to start here in Judiciary and Public Safety. Just to give a little background on psilocybin, it is naturally found in fungi throughout the world. It has been used in indigenous cultures worldwide for thousands of years as a part of religious and therapeutic practices. And it has been used safely by the broader population in the U.S. since the 1950s. It's non-addictive, non-toxic, and there's not a known lethal dose. Psilocybin is showing incredible promise as a treatment for many mental health conditions, yet it remains inaccessible because of its status as a Schedule I drug. We know that people are accessing psilocybin mushrooms already in increasing numbers as their therapeutic potential becomes more visible to the mainstream. So what this bill does is it removes those criminal penalties for use and possession. The author's amendment that we had does remove any mentions of cultivation, which were in the bill as introduced. And that's really, again, just to mirror the specific recommendation from the task force. This bill also establishes a psychedelic medicine board that would be responsible for establishing that possession limit for psilocybin. And both the American Medical Association and Minnesota Medical Association do endorse removing criminal penalties for possession and use, I want to note. We've also seen in certain municipalities, they have deprioritized enforcement of drug laws for natural psychedelics like psilocybin and have done so without incident. So with me here today is Dr. Jessica Nielsen, who is the chair of the Psychedelic Medicine Task Force and is an expert in medical use of psilocybin and can share more about the task force and the bill today.
Dr. Nielsen, welcome to the committee.
Thank you. Chair and distinguished members of the Senate Judiciary and Public Safety Committee, thank you for the opportunity to speak today. My name is Dr. Jessica Nielsen, and I'm testifying in support of SF 4204 as amended to remove criminal penalties for psilocybin-containing mushrooms. I was appointed by Governor Walz in 2023 and elected to serve as the chair of the Psychedelic Medicine Task Force based on my extensive experience doing psychedelic clinical research here in Minnesota, where I conducted the first FDA and DEA-approved research psilocybin clinical trial in the state. The task force submitted our 200-page legislative report last year with recommendations that included removing criminal penalties for use and possession of psilocybin mushrooms. The report thoroughly evaluated their long history of use by indigenous cultures worldwide, scientific evidence for their safe and effective therapeutic uses across a broad range of difficult-to-treat mental health conditions, the expansion of access in other states and countries who have legalized regulated access models to fill the gap in currently available treatment options, and policy considerations for implementation of our recommendations. Psilocybin mushrooms are widely used among the general population, where people often seek them out from underground sources and put themselves at legal risks for the opportunity to experience the profound effects and potential healing uses. Removing criminal penalties around possession and use is a recommendation by both the American Medical Association and the Minnesota Medical Association that all drug use and possession should not have criminal penalties associated with them, as problematic substance use is a health issue, not a criminal one. Colorado has removed criminal penalties for naturally derived psychedelics like psilocybin mushrooms, and dozens of municipalities, as Senator Oumou Verbeten mentioned, around the country have also done so, including right here in Minneapolis in 2023 through an executive order signed by the mayor without negatively impacting public safety around possession and use. While the legislature considers other bills on the recommendations of the Psychedelic Medicine Task Force to implement the Therapeutic Access Program for psilocybin mushrooms, I strongly encourage that this recommendation being considered here to remove criminal penalties for psilocybin mushrooms also be approved. And I do want to direct your attention to the additional letters of support and written testimony by 24 other people, in addition to myself, all in favor of this bill, including physicians, mental health therapists, and other people that have been using psilocybin on their own. Thank you for your time and consideration of this important piece of legislation to help ease the suffering of all Minnesotans.
Thank you, Dr. Nielsen, for your testimony. And members, in your packet, there are all of those letters that were referred to by the testifier. We also have Curtis Hanna has signed up to testify. If you wish to do so, or just available to answer questions, whatever you'd like. Okay, so Mr. Hanna will be available if there are any questions. So open it up for discussion from members of the committee. Senator Limmer.
Thank you. Senator Oumou Verbeten, has the pharmaceutical board weighed in on this bill by any chance?
Senator Oumou Verbeten.
Thank you, Mr. Chair, Senator Limmer. I don't believe they have. I was going to defer to Dr. Jessica Nielsen as well.
Dr. Nielsen.
Yes, thank you, Chair and Senator Limmer. So we met with the Licensing Board and the Board of Pharmacy in relation to the other legislation being passed for the recommendation for a therapeutic access program. The notion here to remove criminal penalties doesn't have any kind of bearing on whether anybody could prescribe these. It really is just asking people not to enforce a federal law, which doesn't really bleed into any kind of prescribing practices or anything that the Board of Pharmacy would have jurisdiction over.
Senator
So,
Limmer.
Mr. Chair, does that mean that the Pharmaceutical Board has no opinion on this legislation?
They have
This is Dr.
thoughts.
Nielsen.
Oh, sorry. Thank
It's
you,
okay,
Chair.
we just need to, for the public record, we need to identify the speakers, that's all.
Appreciate it. Thank
Go
you,
ahead.
Chair. And thank you, Senator Limmer. So they haven't weighed in specifically on this bill. As I mentioned, they've only weighed in on the therapeutic access program because that involves administration by people that have various types of licenses, whether it's a health license for being a mental health provider or a prescriber's license, whether they're a physician or a nurse practitioner. Because this is a Schedule I drug, it's not something that can be prescribed, so it's really not under the purview of the Board of Pharmacy because Schedule I drugs are only allowed to be administered in the context of clinical trials with a DEA license for research. But when it comes to access programs like this, for the other health program, it really is kind of more of a recommendation similar to the medical cannabis program, or any prescriber is not really allowed to, so it's not really something the Board of Pharmacy is able to have any input on because it is a Schedule I drug.
Okay. And Mr. Chair.
Senator Limmer.
Senator Oumou Verbeten on the Medicine Board described on page 6. The membership seems incomplete based on line 6.7, 6.10. How many members would fit into line 6.7 and 6.10 did one have in mind?
Senator Oumou Verbeten.
Thank you, Mr. Chair, Senator Limmer. It certainly is incomplete. I think what we have here today is the start of a framework that we're hoping to build out. One of the questions in this bill is what the possession limit would be, and I feel like it would be best determined by those experts, and hopefully a continuation of some of the folks who have been a part of the psychedelic medicine task force. So this is one potential way to pursue that, creating a medicine board that would include a number of those folks who served on the task force. Those specific details will need to continue to flesh out, but this is sort of the beginning of a framework that we're hoping to develop.
Mr. Chair,
Senator Limmer.
I would be concerned about balance in membership. There doesn't seem to be that with an unlimited number of public members could be appointed by the governor, and nor is there any defining element to who they may be. Are there certain people from a therapeutic community versus people who are perhaps just users? We wouldn't want to have a psychedelic medicine board to be 80% in favor of unbridled use of this product. And so I would be anxious to see a little more balance in the membership. Mr. Chair, what's the intention of the committee on this bill?
To lay the bill over, Senator.
Okay, and then could you explain what the action for damages, how that would apply in a case for is that just restricted to the personal adult use, or is that more for the application of the psychedelic medicine board?
Senator Limmer, that provision was deleted by the A4 amendment.
Oh, it was, okay, thank you. And no further questions at this time.
Mr. Chair.
Senator Oumou Verbeten.
Yeah, I appreciate your comments, Senator Limmer, and I thought it might be helpful just to hear a little bit more about the membership of the Psychedelic Medicine Task Force, where I think we did achieve more of that balance. You know, the recommendations received, I think, a 2/3 majority, but there was really good discussion in that task force, and Dr. Nielsen can talk a little bit more about that.
Dr. Dr. Nielsen.
Chair, thank you, Chair, and thank you, Senator Limmer. So for the Psychedelic Medicine Task Force, the appointments were half from the state, so from state agencies, the Governor's Office, the Department of Public Safety, the Department of Health, the Department of Commerce, and then there was another set. So there was 23 members total on the Psychedelic Medicine Task Force, and then the rest were publicly appointed. So these were volunteers from the public. This included a psychiatrist, a clinical psychologist, an addiction medicine specialist, 2 veterans with treatment-resistant mental health conditions, 2 patients with treatment-resistant mental health conditions, a public health policy expert, and then we had members of the legislature represented. So we had a pretty good bipartisan representative group of people that were kind of talking about these issues from multiple perspectives, from public safety, from a legal standpoint, from lived experience, from the unmet medical need from patients, from providers who were frustrated. And so the idea is to have kind of a pared down version of that for this board to really advise on all these complicated topics for how people can engage with this safely. Thank you.
Senator Seeberger.
Thank you, Mr. Chair. Thank you, Senator Oumou Verbeten, for bringing this bill. Treatment-resistant depression is a devastating illness, devastating. Treatment by medication is a grueling process where different medications it's a trial and error system, and medications can take weeks or months to reach their full effect. When you have tried and failed 2, 3, 4, 5 different types of medications, in my experience, the patient is left in such a state of despair. And I am grateful that alternative therapies are starting to emerge to address this very real problem. Some estimates say that 30% of all people with depression experience treatment-resistant depression. Some say it's as high as 50%. Medication and psychotherapy, talk therapy, do not always provide the answer to folks with depression. I know I am encouraged by ketamine therapy. We've seen great results there. I don't know if folks know, but ECT, electroconvulsive therapy, remains the gold standard when it comes to treatment-resistant depression. But that treatment has a stigma attached to it. If you watch, even watching TV and movies, the shock treatment is always portrayed as some sort of mind-altering, barbaric, cruel treatment that's provided to folks similar to the lobotomies of the 30s and 40s and 50s, and that's not it at all. And that stigma makes it even more difficult for folks to go in and get the treatment that they need when folks can see real improvements through ECT treatment. So I'm grateful we're having this conversation. I'm grateful for the studies that have gone into this particular treatment. I will be a yes on this bill while we're laying it over. If we were voting, I'd be a yes. But I think it's important that we continue to move forward, recognizing the importance of these treatments and the benefits they can do to members of our community. Thanks.
Senator Oumou Verbeten.
Thank you, Mr. Chair. Really appreciate your comments, Senator Seeberger, and it is really heartbreaking to see the way people have struggled to the treatments that are available. And, you know, I talked about in my opening statement how this has been used by cultures and communities for years, right? For thousands of years as a therapeutic practice. And there are other recommendations, and again, I wanted to kind of focus our conversation on removing criminal penalties today, but those other recommendations are so important to look at a therapy pilot, to make sure there's more resources for research on other, you know, psychedelic medicine that can really help people who are struggling with mental health conditions. So grateful for your support.
Senator Kreun.
Thank you, Mr. Chair. So when I've been approached on this bill, it's under the guise of medicinal or therapeutic purposes, and heard a lot about that today. But just so we're understanding the bill that's in front of us, this is decriminalizing recreational use of psychedelics, right?
Senator Oumou Verbeten.
Thank you, Mr. Chair. Senator Kreun, the bill does remove the criminal penalties specifically for use and possession of psilocybin.
Senator Kreun.
Thank you, Mr. Chair. Well, that's certainly interesting. I also noticed that minors under the offenses section would be guilty only of a petty misdemeanor and not to be fined more than $100. So I guess if we catch a minor with LSD, it's less of a serious offense than if we catch them with a beer.
Senator Oumou Verbeten.
Thank you, Mr. Chair, Senator Kreun. I think the goal with this bill really is to follow the guidance from our medical associations to remove penalties, right, for drug use. And then in those situations where we definitely don't want those minors accessing this, I think we'd want to see a substance abuse approach, a public health approach to those situations rather than criminalizing folks. Yeah, and Dr. Nielsen wants to add something.
Dr. Nielsen.
Thank you, Chair, and thank you for the question, Senator Kreun. So the idea around the use here is really about personal possessions amount. It's not a lot, it's not asking, and I wouldn't really call it recreational use. The way that these psychedelic mushrooms are used are really more kind of ritualistic, ceremonial, and therapeutic. They're not really fun experiences. The way that they're used in the therapeutic context, they bring up a lot of really difficult material. And to the point of like whether youth are going to be able to have access to them and what the associated penalties are, I mean, I think if you contrast that to alcohol and other substances that kids have access to, this is far less dangerous and less likely that this is something that kids are using. And we're talking about psilocybin mushrooms, not LSD. That's a completely different substance that the task force did review, but we ultimately didn't move forward on a recommendation because it's a synthetic that we can't easily grow. And that doesn't have the long history of safe use in the world.
Senator Kreun.
Thank you, Mr. Chair. The same concept applies for psychedelic mushrooms. Substitute that for LSD. It's a petty misdemeanor for a minor, whereas a beer is at least a misdemeanor, by my understanding, where you have to actually go to court. It seems like when people go around here selling this as medicinal and therapeutic, then that's what the bill should say, and not when you see it, be like, oh, this is just, we're just decriminalizing it. That's a pretty gigantic step to take on this. But I guess that's just this bill. And if we are going to decriminalize these psychedelics, and I'll say for recreational purposes, despite what your characterization is, because that's accurate. You certainly need to do a whole lot more work than this, and there probably should be several steps in between, starting with having it be done for medicinal purposes under doctors' supervision and all that kind of stuff would seem to me the responsible way to do this.
Chair.
Dr. Nielsen.
Thank you, Chair, and thank you, Senator Kreun. So I think I just want to defer again to the recommendations of the Minnesota Medical Association and the American Medical Association that any type of problematic substance use that's not manufacturing, it's not drug trafficking, it's just simple use and possession really is more of a health concern that should be in the realm of public health officials and medical professionals and not law enforcement. Thank you.
Senator Holmstrom.
Thank you, Mr. Chair. So I want to clarify here, because I too had a conversation with you in my office, and it was my understanding that the goal was to have a limited legalization for the purposes of medicinal testing. So the bill in front of us feels blunt to me. It feels like a misdirect. So the goal is complete legalization for anybody over the age of 21. And really no serious criminalization under that. Is that correct?
Senator Oumou Verbeten.
Mr. Chair, Senator Holmstrom, again, this is really specific to one of the recommendations from the task force limiting this to just personal use and possession and removing the criminal penalties for that. And that's why we want to establish a board, kind of a group of experts that would be looking at what that specific possession limit would be. But again, following that guidance that we don't want folks in possession to face criminal penalties. Dr. Nielsen.
Dr. Nielsen.
Yeah, thank you, Chair Latz, and thank you, Senator Holstrom. So yes, I do want to acknowledge that we have had separate conversations about a different piece of legislation that's moving through independently of this. We were trying to get this bill amended to include the therapy so that could move through in the Senate, but we wanted to keep it focused, I think, for the purpose of this committee to just the removing criminal penalties, which again was one of the recommendations of the task force that's independent of the therapeutic pilot program, which is moving through on its own, and they're not to be confused. So there was some attempt initially to kind of have that be heard here today, but that did not happen, so.
Senator Holmstrom.
Thank you, Mr. Chair. There's two more points of this bill I want to get into. First of all is cultivation. I see that we can cultivate in the primary residence. I don't know anything about growing mushrooms,
Just FYI, Senator Holmstrom, sorry to interrupt, that provision was removed in the amendment that was adopted at the beginning.
Thank you, Mr. Chair. Then we'll skip it. We'll move on. I don't know how you'd acquire it if you can't cultivate it legally, but that could be maybe a question as we continue with this bill. Motor vehicle use. So is there a roadside test similar to some sort of how we do with alcohol, where you blow into a device to determine if somebody is using? Is there something they can do other than just a standard? I have no idea how these work either. Forgive me, I don't often find myself in possession or use of these, or ever. So is there a way that a police officer can know for certain that somebody is under the influence when he pulls them over?
Mr. Hanna, go ahead and introduce yourself and your affiliation and then answer the question.
Thank you, Mr. Chair. My name is Curtis Hanna. I'm the board president of the Psychedelic Access Project. And it's my understanding that right now, similar to cannabis, that the state utilizes drug recognition experts in order to determine impairment. I don't believe that there is any type of breathalyzer for psilocybin. However, I think that there's attempts being made right now to utilize saliva tests. And I do know for a fact that there is the ability to do blood tests to determine whether someone has used psilocybin within the last 24 hours.
Senator Holmstrom.
Thank you, Mr. Chair. And is the ability to test the blood work, is that something that's readily available? Every department could get access to it quickly so that they could actually implement and prosecute under these new terms?
Mr. Hanna.
Mr. Chair, members of the committee, I do not know the answer to that. However, I believe that testing for psilocybin is a fairly common thing that in just regular drug tests, like when you go to try to get a job, they test to see what substances are in your system, and psilocybin is one that's commonly checked. So I believe that law enforcement has this same test, but I don't know the firm answer on that.
So, Senator Holmstrom, every law enforcement agency, in fact, I think probably every squad car has a blood test collection kit in their trunk, which they can use for any impaired driving follow-up investigation. They don't actually insert the needle themselves. They take the suspect to a hospital where a person who's authorized under the statute can draw blood. It gets sealed, put in the kit, and then transmitted to the BCA or another accredited lab for evaluation. But it's quite common for alcohol and for other drug or substance, impaired substance concerns as well.
Thank you, Mr. Chair, for that clarification.
Chair.
Dr. Nielsen, to that point.
Thank you, Chair. Yeah, I have just one additional clarification. So I think similar to testing for cannabis, it's really hard to determine the exact point of intoxication when it comes to these types of blood tests, unlike alcohol, where you can tell somebody based on their blood alcohol content that they are actively intoxicated versus they've just taken the substance within a few days of when the blood test was drawn. So I don't know that it's going to be completely accurate as a blood test that can be administered on site to say this person that's driving is currently intoxicated on this substance.
Yeah, there is no per se level for any controlled substance. With marijuana, there's a difference between the active ingredients and the inactive metabolites that are left over in the system for quite a long time. But they are working on, we've seen some testimony here with regard to pilot projects for saliva tests or portable screening tests. The state patrols have been working on that as well. But the DREs, or the drug recognition evaluators, are trained in testing individuals on a roadside and other places to determine if they appear to be impaired, substance to be determined by a follow-up test if they suspect someone is impaired. Council reminds me that it is a Schedule I substance, so under the current law, even a trace amount of it present in the blood would be considered a violation of our DWI statutes. Senator Holmstrom.
Thank you, Mr. Chair. So that's really the heart of my concern, is that similar to marijuana and federal laws, I worry that what's going to happen is somebody's going to recreationally use this and then find themselves in a heap of legal trouble because they decided to drive to the grocery store 2 days later. And have we gotten feedback from any organizations that do defense work for individuals with DUIs, or have any idea how to help people with this? Because it just feels like we're saying, hey, go do whatever you want, but then on the backside, we're going to be putting people in a lot of harm and a lot of problems.
Dr. Nielsen.
Yes, thank you, Chair. Thank you, Senator Holmstrom. So I think the broader issue here is that people are already doing this pretty frequently, pretty widely in the population. And it's not really something that's causing a significant public health concern, not to say that that's not possible, but people aren't taking a bunch of mushrooms and driving. And if they are, that should be up to like the existing laws that exist for whether you're driving intoxicated or having substances in your system or on your person. I think when it comes to psilocybin mushrooms, it's really a distinct conversation because it's a fundamentally different substance. Like, not all drugs are created equal. Not all Schedule I drugs are the same. The reason why something's on Schedule I, from my perspective as a scientist, is really not evidence-based, but the work that it takes to get it off Schedule I is a whole 30-year process through clinical trials and scientific research, and that process doesn't necessarily reflect what's actually already happening in the community. So the idea of removing criminal penalties allows people to do this safely without having to have additional risks. People are already doing this. This just removes the criminal penalties associated with it, recognizing that it is by and large not nearly as dangerous to the public as things like alcohol, which are already widely available.
Just FYI, apparently today, the DWI task force is considering the other bill involving medical use. So it is a topic of conversation. The DWI task force is not just defense lawyers. It's actually a small portion of it is defense lawyers. Most of it are prosecuting attorneys, law enforcement, other probation officers, others that are involved in this space. Senator Holmstrom, follow up.
Last follow-up on that. So something you had said was that, this is already happening, but certainly when government decides to be permissive about something and actually legalize it, we're going to see more of it happening. We saw that with cannabis. We've seen it with everything. So the concern is, once again, if somebody was not willing to break the law and use this, and now they might be willing to do so, they might not understand all of the long-term effects and what that'll have to do with their other rights in society and their other abilities, and they may find themselves in trouble. That's what I'm trying to get to the heart of.
Senator Westland.
Thank you, Mr. Chair. Thank you, Senator Oumou Verbeten. I know that the Section 8 was removed in the A4 amendment, and just going forward, I would have any concerns if any language were adopted regarding the custody, visiting, parenting time. This actually, and again, I know this has been removed, but just moving forward as we're having the conversations, this actually would have created a different standard for best interest analysis and endangerment than what is currently included in the family law statutes. There is an endangerment standard that is used to determine whether or not there should be a restriction on parenting time. So I would just, if this comes up again, I'm happy to have conversations around that, but I appreciate the fact that that piece was removed.
All right, I'm not seeing any further discussion from members of the committee. Senator Oumou Verbeten, any closing comments before we lay the bill on the table?
Thank you, Mr. Chair. I think it was helpful to gather feedback from the committee today. I appreciate your comments, Senator Westland. That's definitely something we'll look at as we continue to work on the bill. And again, there's a number of recommendations coming from that task force. This was really one specific piece that felt important to discuss in this committee today. But I am supportive of all those recommendations and look forward to working with folks on getting that language correct and hopefully ensuring people have access to this therapeutic medicine.
All right, with that said, the Senate File 4204 is laid over. Members, our final bill for today, Senator Dibble, Senate File 3946. Senator Dibble, my understanding is the plan was to lay this over and that the bill has been heard in transportation. Is that your anticipation as well?
Mr. Chair, I'm agnostic as to what happens ultimately with the bill. I anticipate if you're not going to include it in your package, I would include it in my package. It doesn't need to travel on its own. But we would like the blessing of judiciary on the bill as this bill makes its way to the language of the bill makes its way to the floor by whatever means it needs to travel.
By whatever means possible?
Yeah, I won't say that. That's a dangerous phrase.
Yes. All right, well, why don't we see what the conversation leads to? I mean, we certainly could take action if you ask us to do that and send it to the floor, if that's what you wish to do. And then whether it travels, it gets heard there, or whether it travels separately in something you're putting together, that would be up to you as the chief author.
Great.
If you're looking for the blessing of the committee, however, we'd have to take a vote to bless it or not bless it. So
yeah, if you dislike it, then that's good information too. So
all right.
All right.
So Senator Dibble, let's see, this is coming to us from Judiciary, from Transportation Committee.
Yes.
And I don't see any amendments in the packet for us to consider, right? So
correct.
At this point, why don't you go ahead and describe the bill for us, and then we'll take testimony.
Thank you, Mr. Chair and members, for the opportunity to present Senate File 3946. This is a bill that would address public safety to reflect the reality of today's transit system and protect the full range of workers who serve the public every day in the metro area on our transit system. Under current law, it is a gross misdemeanor to assault a transit operator, and by that term we are referring to a driver or a vehicle operator, the LRT operators. So this bill would update that provision to talk about, rather than transit operators, transit workers, and define that term to include employees, contractors, and volunteers who work on and in public transportation when they are performing their responsibilities. It maintains the existing gross misdemeanor penalty, including for assaults, et cetera, It does not create a new crime or increase penalties. It simply ensures that existing protections apply to all transit workers. The transit system has evolved somewhat in recent years to keep our system safe and functional. More kinds of employees and service providers are present in and on our transit systems. There is the Transit Rider Investment Program that we've created and invested in, and we have what we call TRIP, T-R-I-P, Transit Rider Investment Program agents, community service officers, maintenance and facility staff, and contracted security personnel and service providers. These are the folks who are on the front lines. They interact with the public every day, in sometimes very unpredictable and dynamic environments. Yet the operator, only the person driving the vehicle, is covered by this provision. So that would mean a driver would be protected, but a worker just a few feet away performing essential duties to the traveling public is not protected. So this bill fixes that inconsistency. Like I said, it's reflective of what we're trying to do to make our transit system more convenient, more safe, and more viable for the traveling public. It's similar in concept to other kinds of special enhancements or protections that we provide to other public employees who are out there on the front lines working and interacting with the public every day. So with that, Mr. Chair, just to the bill itself, I think I described it, but the term operators is changed to the term workers, and then what a worker is defined, as you see on lines 115 and 116. And then it provides for an effective date of August 1st of this year. Thank you, Mr. Chair. We have a couple of testifiers, Ms. Conderas, who runs our transit system, and Chief Dotseth, who provides safety and security in our transit system.
All right, let's hear some testimony. Manager Conderas.
Right. Mr. Chair, committee members, my name is Leslie Conderas, and I serve as the General Manager at Metro Transit, which is a division of the Metropolitan Council. Thank you, Senator Dibble, for introducing this Metropolitan Council initiative, Senate File 3946. And thank you for the opportunity to say a few words today about what this agency bill does and why the Metropolitan Council is pursuing this change in law. As you heard, this proposal would apply the enhanced penalties currently in Minnesota law for assaulting transit bus and train operators to other transit workers. Metro Transit is seeking this change because we have other frontline workers who are absolutely essential to making transit happen that aren't covered by the current law. This includes trip agents who inspect fares, community service officers who provide official presence on our system, public facility workers who clean stations and platforms, and other positions who are all essential to providing transit service. Metro Transit is supporting this bill because we believe that there should be parity across these groups when imposing a penalty for assault. This is important because without people, there is no transit, and the safety of our employees as well as our riders comes first. At Metro Transit, our mission is to connect people, strengthen communities, and improve lives by delivering high-quality public transportation. We deliver about 50 million rides a year, or an average of 160,000 rides each average weekday across more than 60 communities in the metro area. And at Metro Transit, we are making significant investments in improving public safety on transit, which includes adding more frontline workers to our system. We are seeing improvement from these investments. Just for example, in 2025, serious crime was down about 14% compared to 2024. Yet, we do still have instances of transit worker assault. And from our perspective, even one assault of a transit worker is one assault too many. So bringing parity to the penalty for assaulting transit workers, whether they are bus or train operators already covered by these enhanced penalties or in other positions where they're not, is equally important and would convey the value that all employees have to the transit service that our region relies on. So thank you, Mr. Chair. I'll mention Chief Dotseth is here with me as well. He's the chief of the Metro Transit Police Department, and we are both available to answer any questions you may have. So thank you, Chair, for the opportunity to testify.
Thank you, Ms. Conderas. Chief Dotseth, welcome to the committee.
Chair, committee members, good afternoon. My name is Joe Dotseth. I'm the Chief of Police at Metro Transit. And I also would like to thank Senator Dibble for bringing this legislation forward. And my statement's really going to echo a lot of what General Manager Candera said. We've made significant improvements on the transit system with the investments, thanks to the legislature and all of the work that we've done to improve safety and security on the transit system. It's working. And crime is down, right? And so as we think about how we're supporting the perception of safety, it's my opinion that this bill is going to also help us create that environment for our employees to feel valued and supported. The frontline workers out on the transit system, which includes the trip agents, our facility workers, and our community service officer programs really deserve the same protections as the transit operators do as well. We heard testimony earlier today on another bill about the importance of the community service officer programs as a pathway to policing, and I'm very excited of the work that we've done in Metro Transit and the police department to not just rebrand and rebuild back our police department and focus on safety, providing that service to our members and our employees, but our community service officer program, starting next week, we have 44 CSOs, and I'm quite sure that early summer we're going to be at 55, which is our max. We've built back that program from 9 CSOs just a couple years ago to approaching 55 here shortly, and I want to ensure that they have the same protections when they're out on the system that the police officers do. And with that, happy to take questions as well. And again, thank you for allowing us this opportunity.
Thank you, Chief. And can you tell me, the CSOs, they're employees, is that right?
Chair, committee members, that is correct. Community Service Officer Program, our community service officers are generally they're students going to law enforcement. That's kind of our cadet program, but they are employees at the Metro Transit Police Department. They wear a gray uniform. One of their primary functions is being visible on the system.
And what's the role of volunteers that would also be covered here within your workforce, if you will?
I can take that.
Ms. Canderas.
Yes, Chair Latz, committee members. So currently that's included in the definition to cover any potential transit worker, but in practice, we don't actively have a volunteer program. So that's not really our focus with this, but included it in the language to be fully comprehensive. So.
Yeah, the only place that, at least on a quick review, that we can find where volunteers are covered by enhanced penalties is volunteer firefighters. And
okay.
firefighter is kind of a whole different structure system, so I think that makes sense. I'm a little bit concerned about including volunteers in this system. I recognize the value and importance of everyone who's involved in transit safety. I'm just trying to figure out how we draw that distinction as we expand enhanced penalties for assaults. Any thoughts on that would be welcome. Any questions or discussion from members of the committee at this time? Senator Pappas.
Mr. Chairman, I just really want to thank the Met Council and the transit folks. I take the light rail, and I've really noticed a significant difference. And lots and lots of transit officers, workers, whatever you're calling them, on the light rail and checking tickets. And I think it's provided much more of a feeling of kind of safety. And I just wish more people would get back on the light rail.
Senator Dibble.
I just wanted to thank Senator Pappas. That was an observation that I shared when I presented this bill in transportation. Judd Shetnan, who's in the back of the room now, doesn't actually get text from me while I'm on the train expressing great happiness when I see fares being checked, because it happens frequently enough now that it's not a one-off occasional. I should be texting him when I actually don't experience smoking on trains, because I used to text him constantly when there were people smoking on the trains, which drove me completely and totally bananas. And I haven't experienced that sort of kind of social disorder or observed those kinds of behaviors on the train or the bus for a while, and that's because we've invested in the TRIP program. It's been very successful.
I see Mr. Shetton in the back expressing a lot of gratitude for not receiving all those texts from Senator Dibble while you're riding. I will tell you, there was a big rally here at the Capitol a couple of weeks ago, and I drove, but the light rail was absolutely jam-packed after the rally as people were leaving. So it certainly has a big role in transporting people to and from events anyway.
So, Mr. Chair,
Senator Dibble.
don't want to overstate my case. There's still a lot to be done. Part of that is addressed.
Sorry, Mr. Shen.
Yeah. It's a work in progress, and most of what's going to address safety and perceptions of safety and security is getting riders back to LRT. And it has been improving steadily. I know maybe Ms. Canderas can talk about the ridership numbers a little bit if you're interested. It has been going up. It kind of goes up, and then but in general the trends are in the right direction in terms post-COVID. What happened during COVID was there were so few people on that led to the rise of social disorder and kind of chaotic circumstances on LRT and bus rapid transit and the regular route bus system, and because more people are coming back. The TRIP program is huge, but like they say, eyes on the street is the best tonic for public safety. Riders on trains and buses likewise.
Yeah. Well, there are lots of places we can go with the conversation, from North Star Rail and the fact that it ended at Big Lake for purely political reasons back when it was initially authorized, and issues around the metropolitan area with the other suburban bus lines as well. There's a lot of issues, but all we're working on today is whether to expand our fourth-degree assault statute to cover folks on the train. So, Senator Limmer.
Thank you, Mr. Chair. Senator Dibble, I remember we've had discussion about the difficulties on the light rail lines over recent years. But I was a little curious about lines 1.8 regarding the assault using bodily fluids that are thrown onto workers. We have existing law that recognizes the same assault, but on people who work in correction facilities and police officers. That would get you a felony charge, and in this case, it recognizes it as a gross misdemeanor. Is there a reason why the underlying charge would only be limited to a gross misdemeanor?
Senator Dibble.
Thank you, Mr. Chair. Senator Limmer, I don't know the reason. Like you pointed out, that is existing law. Maybe Mr. Backus has some knowledge of the history of that element of the law that we're updating.
Mr. Backus.
And why this would be a lower standard than you'd find inside of a corrections institution.
Mr. Backus.
Mr. Chair and members, I think it's just the way the fourth-degree assault law has been changed over the years. Certain classes of victims have been given greater protections than others. So peace officers generally are going to have that higher level of protection compared to, say, transit workers or other people.
Mr. Chair.
Senator Limmer.
This is just a reminder of a conversation I have often. We continue to write enhanced penalties for certain people in Minnesota and not for others. I find it also curious that a transit passenger is not included in this particular bill either. The most innocent of people in the drama that would play out in a light rail or a transit location. So just a note to put into the public record that we're getting to the point now by enhancing penalties that the only one that does not get an enhanced penalty is the hardworking taxpayer in the state of Minnesota. And that's all I have to say about that, Mr. Chair. But I would suggest before this goes to the floor that you might consider at least transit passenger. They're in a position where they're a captive audience. They can't escape a transit facility or a vehicle, and they may not necessarily get the gross misdemeanor enhancement. I don't know if that's appropriate for an amendment at this point, Mr. Chair. Leave it up to the committee.
Well, Senator Limmer, it's in front of the committee. Any topic is fair for an amendment if you wish to offer it.
Well, Mr. Chair,
Get a temperature of the chief author on that. We could also revisit the question of whether volunteers should be included as well, especially since they don't use volunteers at this time. But you'd have the prospect of passengers assaulting passengers facing enhanced penalties. So it's up to you, Senator Limmer, whether you wish to offer an amendment.
well, I'll be guilty of my own criticism, but nevertheless, I would need some help from council, but to put into the bill, to amend the bill to include transit passenger. I don't know if, I haven't talked to the chief author about this, this is on the fly, but nevertheless, I think it would be appropriate in light of a passenger paying for their fare being contained in being contained as a captive audience to something, and that they should, or anyone who is guilty of assaulting a transit passenger in the same manner as described here should also be included.
Well, we may need a little bit of time to draft this because it doesn't fit as neatly into the framework that's listed right now.
Mr. Chair, what is the intent
Senator
of the bill for this one?
Well, we were trying to determine that at the beginning, whether we want to just lay it over, give feedback to the chief author, or move the bill onto the floor. Came to us initially, it was sent before we had a hearing over to transportation because they wanted to hear it, and sent it back to us. So the bill doesn't exist right now in any other location than right here, but so it's within our purview to do what we wish at this point. Kind of get a sense of, after our conversation, what the chief author would like us to do with the bill. Council's identified the fact that assaults include assault fear, not just assault harm. So every intimidating tactic on a transit bus or a light rail could end up with a charge between passengers, and there might be a fiscal impact if you end up increasing citations, especially when you're got that many more CSOs and folks monitoring behavior on the trains. So,
Mr. Chair, I don't wish to delay the bill. It certainly has merit in its present condition. I'll work with council as well as chief author, see if we can come up with a direction that we can all agree with. And I think that would be appropriate at this time. I don't want to delay the proceeding at this time. I'll withdraw my suggestion.
So, Mr. Chair.
Senator Dibble.
I just wanted to respond to Senator Limmer. I find the suggestion intriguing, interesting. In my sidebars, the manager of the transit system and the chief of police do as well. And I think what they would like to do is to take this conversation back to the agency, and they also have, a rider, what do you call that rider group that you consult with? Yeah. The rider group they consult with, to have the conversation there as well. But I will also commit to continuing the conversation yet in this session with my good friend, Senator Limmer. I would say that we'd work on it together next year, but he might have to come back as an activist and advocate.
I don't think anyone wants me to do that.
So Senator Kreun's next on the list, but what I'm thinking about, Senator Dibble, is if there's some conversation to be had around some amendments that might take some consideration, is theoretically anyway, we could lay the bill over today and bring it back next week. We've got 2, maybe 3 hearings next week, which would still give us an opportunity to fine tune it before we send it out of here.
Mr. Chair, that's perfectly acceptable. I'm not, if it's going to be included in the transportation package, we wouldn't be marking that up and sending it out of transportation until Wednesday. We're going to roll out our initial proposal on Monday and then do testimony markup and voting it out on Wednesday of next week. So
Yeah,
we have plenty of time.
The lines are getting a little bit fuzzy this year in terms of jurisdiction, but we should have a conversation as to including a purely criminal provision change in the transportation package as well. So that's a sidebar
Yeah,
conversation.
that's totally fine too. Yeah, I mean, it can travel anywhere or not at all. If people don't like it, that's fine too.
Well, we are talking transit, so traveling somewhere is usually a good idea.
Oh, now. Senator Swazinski is not in this.
Senator Kreun.
Thank you, Mr. Chair, and not to blow this up even further, but I think when I think about this, I share Senator Limmer's concerns about enhanced penalties for protected classes of individuals, or certain classes of individuals. You really kind of, once the legislature in its wisdom decided to go down that road, there's really no end to that road, and I think we're kind of seeing that now. Not that I'm opposed to this bill, I'm not, but when I look at line 1.7 and line 1.8 and talking about intentionally throwing or otherwise transferring bodily fluids onto a transit operator or expand it to a transit worker and make that a gross misdemeanor, I immediately think that anybody who intentionally and without consent throws or otherwise transfers bodily fluids onto somebody should be guilty of a gross misdemeanor. I don't know why we're even limiting this to the transit. It doesn't make any sense to me. That should be at a minimum a gross misdemeanor, just as a matter of criminal law. So that would be the amendment I would like to see. It may not be applicable, or you may not want that in this particular bill, which has to do with transit workers, but to me, that's the easiest solution, is just make that baseline a gross misdemeanor for everybody. But I'm not going to suggest an amendment and make staff go through that for this bill, because that would be kind of overly expansive. But that's what I think. Certainly doesn't bother me to make it a gross misdemeanor for transit workers, but I think it should be in all cases. So that's one comment I have. The other comment, if we're talking about making it safer for transit workers, I would think funding more transit officers would be more effective. And making so that the transit workers are not assaulted in the first place. Maybe there's some deterrent effect here by enhancing penalties, but ultimately stricter enforcement, I think, would make the workplace more safe for the transit workers. I had a bill that would allocate $7.5 million to more transit officers, and Senator Dibble, you were kind enough to give that bill a hearing. Of course, it didn't get funded. But to me, that's the best way to go here. That doesn't mean I'm opposed to the bill. I'll support the bill. But ultimately, and I'm glad to hear that it's getting better, because when I presented that bill, the horror stories were unbelievable about what it was like to ride the light rail, and some of the news stories that I've read were heartbreaking to read. But even if it's gotten better, I trust that it still has a long way to go. And ultimately, to get this under control, I think we need more law enforcement, and if that means more transit officers and other measures, that's what I would support ultimately, to make it safer for passengers and for workers. But in the meantime, I don't, given the fact that the horse is already out of the barn, so to speak, on these, enhanced penalties for certain classes of individuals, I don't think this very modest expansion offends my sensibilities, so I'll support the bill.
Senator Holmstrom.
Thank you, Mr. Chair. Senator Dibble, I believe that I'm reading this to be an escalating clause, meaning that if you do this to these protected classes, it would be a higher crime than if you did it to the general public. Is that correct?
Senator Dibble.
Chair Latz, Senator Holmstrom, that's absolutely correct, yes.
Mr. Chair.
Senator Holmstrom.
Thank you, Mr. Chair. So I guess I have to ask, what's the benefit of creating a higher consequence in general? What would be what are you trying to accomplish by creating a higher penalty in general?
Senator Dibble.
Thank you, Chair Latz, Senator Holmstrom. It's similar to the conversation we've been having with Senator Lemmer and Senator Kreun. This idea of enhanced penalties for assaults against certain kinds of public employees that are frontline employees, police officers, Department of Corrections agents, transit operators, et cetera, who provide a unique set of services and have a unique exposure, susceptibility. They're out there, for the entirety of their workday, and they're providing an essential service, et cetera. In the legislature's eminent wisdom, back when, I'm not sure when exactly, decided to send a signal to the public that these are employees who hold a special public trust serving the larger public, and an assault or an offense against them, for whatever reason is differentiated as a higher level of transgression. So that's the, I think that was the kind of the public policy philosophies before my time, so I'm, taking a stab at it. And so I think the idea that was brought by the employees of the Met Council in conversation with their leadership is, hey, there's a lot more of us out there, doing this kind of work that's comparable to the essential function of public transit, as essential as the person actually driving the vehicle. We should have that same standard of protection. So, but if you have a different philosophical perspective, everyone should enjoy the same level of sanction, whether you're a member of the public or a public employee who's serving the public. I respect that, and I'm willing to engage in that conversation.
Senator Holmstrom.
Thank you, Mr. Chair. So I just want to clarify, it seems like the intent is to deter future crimes from occurring by increasing these penalties.
Senator Dibble.
Senator Latz, Senator Holmstrom, yes. I mean, I think that has a lot to do with a lot of things that we call crimes. We make them a crime so that then people, if they do them, will suffer consequences, so they might think about not doing them in the first place.
Senator Holmstrom.
Thank you, Mr. Chair, and I appreciate you saying that, and I appreciate that you agree that deterrence is the reason. We heard testimony earlier today that deterrence is not an effective, increased penalties is not an effective deterrence for crime, and I'm glad that you and I can agree that it certainly is. I'll be supporting this bill. Thank you.
That sounds like a pretty broad generalization, Senator Holmstrom, from our earlier conversation. Part of that conversation was whether or not the conduct should in fact even be considered a crime or treated as a public health issue rather than a crime. But that's a different conversation, I think. Senator Lemmer.
Thank you, Mr. Chair.
I'll stick with you.
Senator
Holmstrom.
I'll clarify. This was actually on a bill that you weren't in the room for. This was in reference to a corrections bill, but thank you.
Well, I happen to agree with Senator Kreun that the greatest deterrent is the likelihood of being caught, not the penalty that might follow if one is caught, run through the system, and convicted and sentenced. And that's the case with DWIs, just like it is with probably all traffic matters and lots of other crimes. If you think you can get away with it and you're inclined to try, you're more likely to give it a try than if you think you're going to get caught and not get away with it. So the penalty certainly is a component to deterrence. That's basic. That's criminal justice philosophy 101. But whether it's the most effective means of deterring crime or not is a different question.
Mr. Chair.
Senator Dibble.
I did want to respond briefly to Senator Kreun, because of his statements are kind of just left hanging. Some might remain with the impression that we have done nothing with respect to increasing both the number of officers as well as other kinds of employees who are responding to and catching people and deterring and or dissuading or turning aside or having that preventative effect. The CSOs, the trip agents, other kinds of employees, contracted security, et cetera. And the other benefit, of course, is that as we add even more cops, we free them up to respond. First of all, they're able to be called in on a more timely basis to issues as they're occurring and are responding to those kinds of things that are appropriate for police to respond to, freeing them up to respond to more of those kinds of things to either put a stop to them, hold people accountable, or deter. And so so it's all additive. And we have actually, with the pressure that a bill like yours provided, no one will ever say I've been easy on Metro Transit with respect to these security issues that were cropping up back in those days. And the pressure and the leadership and the response to our public that we brought to bear has resulted in a lot of improvement, including more cops and more kinds of security and community personnel who effectuate both a police response and also a more appropriate level of response to incidents that they can respond to without police intervention.
Senator Limmer.
Thank you, Mr. Chair. Just as a little historical footnote, when I was in the House as a member.
This is way historical.
This goes way back. I don't even think they had public records then. But the whole concept of enhanced penalties came about when police officers were being assaulted at a little higher rate than others at other times. And the concept of enhanced penalty was applied to figures in authority. The figures in authority that were enacting or fulfilling or administrating our policies that were written into state statute. There are times when there are more rebellious citizens that want to assault the members of our public service that are fulfilling our wishes in state statute. And the enhanced penalties began at that point. Since then, enhanced penalties have been added into a variety of occupations, but for the most part, they were figures of authority. Building inspectors, prosecutors, judges have been added. But lately, there has been added more and more occupations that don't necessarily fit the authority figure, and everyone who has an occupation thinks that they are deserving of an enhanced penalty if they are treated poorly by the public. And that's where it has come, that's where it started, that's where it is now, but it seems to be getting a little out of hand. And the public, the general public, is getting a little forgotten in the process. Having said that, I am in support of Senator Dibble's bill. These are people that are providing service. These are people, many of them in an authority position, and they should deserve the same or an enhanced penalty if attacked in such a manner.
Senator Dibble, what is your desire with regard to the path of the bill? We could take a vote and send it to the floor. Sounds like there would be support on the committee to do that, or we could lay it over if you want to noodle on some of the issues relating to passengers or volunteers, and we could take it up again next week to pass it on to the floor at that time. You're the chief author.
Mr. Chair, it would be my desire to take a vote, move it to the floor, or we can move it back to transportation. We can do whatever you send, but I would appreciate an affirmative vote if that's the will of the committee, at least on the underlying bill. And I don't think that would necessarily preclude some of these ideas if you take it into your bill, especially because that would then, of course, then be the subject of more judiciary conversation. We can have that conversation about what would happen with the ultimate language, because I don't anticipate we would necessarily take this up as a standalone on the floor, but I would appreciate an affirmative signal coming from this august body today.
Ooh. Oh, I might change my mind on this bill now. All right, well, I think we should entertain a motion then to recommend that it pass and be sent to the Senate floor, and then if there's a dual track process, that can take its own path as well.
Great.
Fair enough, Senator Dibble? So, are any motions to that effect? Senator Limmer moves that Senate File 3946 be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails.
Thank you, Mr. Chair and members.
Thank you for the conversation today, members. The next hearing is going to be Monday, April 13th at 12:30, back in the Capitol Room G15. Have a great weekend, everyone. We are adjourned.